pray in your holy name. Amen.
Thank you very much. Everyone, please take your seats. Let me recognize my two good friends.
Janet Grace Fabrero. Good morning. Deputy Regional Prosecutor Raul Cristoria. Good morning, sir. City Prosecutor Lisa M. Jorda. Deputy City Prosecutor Freddy Nohara. Good morning, sir. Assistant City Prosecutor Kim Espina. Attorney Marines Ledesma Codedano. Good morning. And Attorney City Asya Gani. Good morning. City Prosecutor Sheila Mar Saliganan Abadia. Good morning, ma'am. Sorry. From the United Nations Office on Drugs and Crimes, we have Attorney Kirby Tibayan and Dr. Nick Tobia. Good morning, sirs. From the University of the Philippines Law School, Professor Dan Kalika, Professor Neil Anthony Borja, and from the University of the Philippine Law Center, Institute of Government and Law Reform, Attorney Fenisa Estigoy. Good morning. From Legal Education Board, we have Attorney Mark Benedict Sampaga. Good morning. From the Public Attorney's Office, we have Attorney Noliver Barido. Good morning. Attorney Maria Angela Hernandez. From Ateneo Law School, we have Attorney Harvey Bilang. And from that would be all, Madam Chair.
Thank you, Comsec. So good morning, everyone. I am happy to be with lawyers again. This will be a very brief opening remarks. I just want to thank all of you for your patience and for being here every week and for sharing your insights, for helping us in crafting the new penal code. So let me just summarize where we ended last meeting. We tackled Article 12, mitigating circumstances. Okay, I'll read these one by one. So, in relation to paragraph 3, no intention to commit so grave a crime, the body agreed to retain the word crime for consistency as the offender is already committing a felony. Paragraph 5, on proximate vindication, the body agreed to replace crime with wrong to broaden its application as a grave wrong. 3, no intention to commit so grave a crime. The body agreed to retain the word crime for consistency as the offender is already committing a felony. Paragraph 5, on proximate vindication, the body agreed to replace crime with wrong to broaden its application as a grave wrong need not itself be a crime to provoke the offender. Third, relationship terms. It was agreed that we leave the terms spouse, ascendants as is for now. We have plans of consolidating all of these definitions that we will later find as we go through the penal code into definition of terms at the beginning of the penal code, and provision on statutory construction as well. On physical and mental disability versus illness, the body clarified the distinction. Paragraph 9 pertains to diminution of freedom of action due to physical or mental disability. Paragraph 10 pertains to diminution of intelligence volition due to illness. Next, it was agreed to transfer references to mental disability from paragraph 9 to paragraph 10, so there won't be any overlap. Paragraph 11, analogous circumstances. The body retained this provision. The proposal to expressly include restitution or apology as a mitigating circumstance was discussed, but this was not adopted. Next, alternative circumstances. The body agreed to delete the separate chapter and incorporate its elements, such as intoxication, relationship, into the mitigating or aggravating circumstances as appropriate. Okay, next on Article 13, aggravating circumstances. This is where we left off. This is where we stopped. The general comment is, it was suggested that aggravating circumstances should imply deliberate, conscious, or intentional use of the advantage, such as taking advantage of nighttime rather than just having during nighttime in the provision. On paragraph 1, public position, the body agreed to retain the phrase takes advantage of his public position. It was decided that adding qualifiers like influence or function could overcomplicate the provision and increase the prosecution's burden of proof. So we will, as discussed, we will go through jurisprudence where it says that abuse of position already includes influence. Paragraph 9, habituality and recidivism. This provision was significantly revised to simplify the previous concepts of recidivism, reiteration, and habitual delinquency. The agreed wording is that the offender who has been previously convicted by final judgment or previously punished of a crime punishable by correctional penalties commits and is convicted of a subsequent crime. On quasi-recidivism, the body agreed to insert a new paragraph after paragraph 9 to cover quasi-recidivism. Paragraph 7, nighttime uninhabited place. The body agreed to update the provision to reflect modern circumstances. The agreed wording is that a crime be committed taking advantage of nighttime or in an uninhabited place or other circumstances that will ensure impunity to facilitate the commission of the crime. And paragraph 3, insult, respect, and paragraph 25, discrimination. A proposal was made to merge these into a single provision on crimes committed with deliberate disregard for dignity or abuse of a victim's vulnerability, such as race, gender, disability. Final wording was deferred for submission. So that's where we left off. And for everyone's information, of course, we're going through every single provision here. After we have finished our discussions, we will come up, of course, with a substitute bill, which we will, again, send to everyone for your comment. It's very lengthy, so, okay. Maybe to fast-track the proceedings, especially here under aggravating circumstances, can I get your comments on aggravating circumstances? So anyone can start. Okay, let's pause.
Madam Chair.
Yes, before we go to aggravating circumstances, yes, Congresswoman Ana Velosa-Tuason.
Madam Chair, before we proceed to tackle aggravating circumstances, I move that we approve the minutes of the meeting for February 18 and 24.
A second, Madam Chair.
Okay, there is 18 and 24, and the same has been seconded, and there being no objection, The minutes are approved. Okay, going back to aggravating circumstances. Comments on the remaining.
Are related. There's no need to have a separate enumeration of that the crime be committed in a place dedicated to religious worship. We can incorporate it in paragraph 5 to abbreviate or for clarity purposes, Madam
Number
Chair.
5 is
That the crime
be committed in the palace of the president or in the latter's presence or where public authorities are engaged in the discharge of their duties. Is that correct, sir?
Yes, Madam Chair.
And number 6 is that the crime be committed in a place dedicated to religious worship.
We can just add the phrase in number 6 to number 5. There's no need to separate them, Madam Chair. Anyway, it is this 5 and 6 pertain to places where a crime is committed. Can we just incorporate 6 to 5?
Comments? It's a matter of style. Actually,
we are making the disregard of the place as an aggravating circumstances. It would be there's more reason to make an aggravating circumstance the disregard of the ongoing religious activity when the crime was committed.
Prosecutor Horda.
Hello, Madam Chair. Good morning to all. My observation is that Prosecutor Nahara suggested that it has to be consolidated with 5 and 6. However, my observation is such that um, I would suggest that it would be retained. I mean, it should be separate, because take note that number 5, paragraph 5, does not only speak of the palace of the president, but there is a
Presence.
continuation, or in the latter's presence, or where public authorities are engaged in the discharge of their duties. So it is very specific. It has something to do with a public authority and the
Correct.
president's
I agree.
presence. So that's why I would suggest that it has to be separate for, simplification, for clarity also.
Thank you. Thank you for your comments. Okay. What is the proposed language for number 6? How? What is your suggested wording for number 6?
Madam Chair, our proposal is that the crime be committed in a place dedicated to religious worship or during an organized religious activity, regardless of the place.
Yes,
Madam Chair,
Prosecutor.
sorry. Uh, uh, how to word it? We were thinking about what our colleague attorney Bilang said regarding the place. Kasi nga yung family na magdadasal, it's a religious yung kanyang term, activity. Maybe we could place in a place dedicated to religious worship or during a mass religious activity, to indicate na halimbawa sa park sila, nagmimisa doon sa park na maraming tao. It's a mass religious activity. Hindi siya centered yung maliliit na pocket size na ano. Organized mass religious
Or-
activity.
Does it have to be mass? I mean, mass, yes. Mass na group.
Yung
madami.
mass na
Yeah. Or during an organized religious activity.
can be po. Just to indicate yung the size.
Because it can be, no, I mean, it can be a small group, but it's still I know where you're coming from. You're drawing a line between like a family gathering, family praying together versus a group, an organized religious activity. But it doesn't have to be a big religious activity. So can it be just an organized religious activity? Yes, attorney.
Madam Chair, maybe we can correlate this to the original Article 132 of the revised penal code. We also have that in Article 114 of House Bill number 7140, which is the interruption of religious worship. What was used here is who shall prevent or disturb the ceremonies or manifestations of religion. So instead of using mass, we can use ceremonies or manifestations of any religion. So this is the wording used in 114. But my concern is we already have this provision. It is punishable as a crime. And then we have another aggravating. Although for the aggravating circumstance, you commit any crime, and then your penalty will be one degree
One
higher,
degree
or
higher.
yes, one tier higher. But this is a separate crime, the
Aggravating.
interruption of religious worship. So I just wanted that to be taken into consideration. Thank you.
Okay, I understand. So there is a separate crime for interruption of religious activity, whereas here under aggravating circumstances, the fact that a crime was committed in a religious place or in the presence of people having a religious ceremony, it becomes an aggravating circumstance. But obviously, there's a distinction, right? One is about interruption. Okay. So, am I correct to assume that it's clear that they're different, right? I mean, there are other crimes can be committed, and that can be aggravated by this. Okay. Okay, are we agreeable to inserting the proposal of yes, that the crime be committed in a place dedicated to religious worship or during religious ceremonies or manifestations of religion of any. Yes.
And just a legal rephrasing, how about within a place dedicated to religious worship?
In a place.
That the crime be committed within a place dedicated to religious worship.
Okay. Is there a
Within a place.
but if it's outside? Okay, go ahead.
Madam Chair, so for paragraph 6, it will, based on the proposed amendments, it will now read as follows: that the crime be committed within a place dedicated to religious worship or during a religious activity, or religious ceremonies or manifestations of any religion,
Okay.
regardless of the place.
Okay, subject to style.
Subject to style.
Second.
Thank you.
Okay, so there's a motion to adopt paragraph 6 as worded earlier, which has been seconded. We adopt paragraph 6 of Article 13. Next, do we have other comments? Yes? My favorite professors.
Thank you, Your Honor. On paragraph 2, with respect to persons in authority,
Okay.
as defined in Article 140, I've also come across Section 388 of the Local Government Code, which also enumerates other persons in authority, that they are punong barangay, sangguniang barangay members, and members of the
Taken into consideration as well. Thank you.
Okay.
It's Article 154 under House Bill 7142 and 7206.
Hindi umabot ang printout. We'll note that. But in essence, we will approve the proposal to add the other laws. And then we will relate it to Article 152, 154. Okay, so Kong Ana, can you move to adopt
Madam Chair,
the amendment number 2?
Madam Chair, for Article 13, Paragraph 2, I move to amend Paragraph 2 to drop the term in Article 140 to capture also the other jurisprudential, no, sorry, other statutory laws defining persons in authority in relation to Article 154, also of House Bill 7142.
Okay.
Second, Madam Chair.
Okay, so there's a motion to adopt Article 13, Paragraph 2, and this has been seconded. We will revise same and amend as suggested. Okay, next. Yes, Prof. Dan.
Good morning, everyone.
Good morning.
With regard to paragraph 22, it states that the crime be committed with the aid of a child. It presupposes that the child is also an offender, but there's already a different view of a child under Republic Act 9344. We call them children in conflict with the law. Usually, they're the ones who are abused or exploited by criminals. So,
Correct.
just to jive with what is provided in Republic Act 9344, may propose, if the GOJ is amenable, that we restate this to state that the offender or offenders takes advantage of, or profits from the use of children in the commission of a crime. That's okay with the DOJ po.
Yes, that actually sounds better than just that a crime be committed with the aid of a child. Of course, it seems very vague. Yes, Prosecutor Nohara.
The present wording of the law is if a crime is committed with the aid of a child whose age is less than 15 years. So in the draft, there is no mention about a certain age. So when we speak of a child, it means that he is below 18. So there is a sudden departure from the present wordings. So are we going to adopt the present wording of the law, or we will interpret this child as one who is below 18? So another problem is if this aggravating circumstance exists if the child is not the offender himself. But if he is offender, he will be treated as an offender under Republic Act 9344. So he is now an offender. He is a perpetrator of a crime, no longer an aggravating circumstance under this Article 13. So I think I would suggest that this must be clarified, not only with respect to the age, but with respect to the participation of the child. If he is an offender who is a mere accessory, or he accomplice, or he is present in order to aid other perpetrators. Thank you, Madam Chair.
Okay, Professor
Yes.
Dan.
I agree with the observations, precisely the proposed revision, because the children now are considered as children in conflict with the law. And that may mean he or she is the offender, the victim, or one being used to commit crimes. And whether he or she is an offender, it's already covered by RA
By
9344. In fact, we
yes.
already included in the exempting circumstances that a person who is 15 years old and under would be exempt, and then over 15 and under 18, he or she will be exempt also, unless he or she acted with discernment. So I
Discernment.
think on the side of being a party to the commission of a crime, that's already covered by exempting circumstances. And I would assume there's also a privilege mitigating circumstance if he or she is convicted. I saw that already in the succeeding paragraphs. But here, it says with the aid of a child.
There
And
is a
of course,
person, and then he uses another child
in the commission
in
of
the
a crime,
commission of
okay,
crime.
which is actually observed in recent cases, because under Republic Act 9344, the criminal syndicates or the criminal offender uh, knows that there's an opportunity for them to use children, because the children are exempt from criminal
Example po
liability.
siguro nito, kunyari may papanakaw,
Yes,
gagamitin yung
yes.
bata. Uutusan siyang kumuha,
Yes.
sumungkit
Knowing that the child is exempt
from
from
criminal liability.
criminal liability. So that's the wording actually in Section 20C of RA 9344 as amended. So we're just suggesting the wording. And then as to the definition of children, we agree that there should be in the construction or interpretation of words or terms under this code, we suggest that children be one who is under 18 years old or above 18 but is incapable of protecting himself or herself, as already stated in many special penal laws adopted by the Congress. Okay, that would clarify the definition of children. So it's not limited to a particular set of children po. Thank you.
Compared to dun sa original na
Wording na
the
under 15
under
lang.
15.
Yes.
Okay. Yes, Prof.
Can I just make this rejoinder? Assuming a 17-year-old child is one of the... Wala siyang criminal liability. But if he's under 15, wala siyang criminal liability because that is an exempting circumstance. Pero pag natawid niya yung 15 years and 1 day, below 17, meron na siyang criminal liability if he acts with discernment. So, anong treatment ng batas under the proposed draft with respect to the boy who acts with discernment? That must be defined. That must be established kung anong treatment sa kanya. That's because this will, I'm sure this will create a lot of confusion among the stakeholders, and kakailangan na naman ng Supreme Court decision dito later.
Go ahead.
Precisely, Madam Chair, the proposed terminology is it's the offender who uses the child or takes advantage of the child. Okay. So the treatment of a child who is the one who's participating in a crime is covered already by the same thing circumstance or by Republic Act 9344 po. So I think that's very clear in the Juvenile Justice and Welfare Act. I think the new circumstance is what if the child is a party to a band or a group of persons, including adults, who commit the crime po. Okay? That's the different circumstance. Okay? Because if the child is also a party, a co-conspirator to the commission of the crime, then he or she will be
Charged
subject to the
under
RA
9344.
9344 po. So
I think
here,
that's my understanding.
Yes po, Madam Chair.
It might be a little basic, but I don't know if this will be difficult for the prosecutors, but tama ba ho na it is for them to appreciate the circumstances of a case. So kung makita nila na ginamit lang talaga yung bata, then it's an aggravating circumstance for the adult. Whereas if the child really had was really part of the plan and are actively participating there without instruction, then it's under 9344. Yes, prosecutor.
Actually, we have a case in Tacloban. The leader of the gang was a minor. He was a minor, and then members niya are all adults. Siya, hindi siya na ano, he was not proceeded, he was proceeded under 9344. But yung mga adults, they really, without bail because it was murder. So the leader of the gang, he was not used by any adult to commit a crime. Instead, he was the leader of the gang. So we have that scenario. He was proceeded upon under Republic Act 9344, while the rest, they are now in jail without bail. Imagine that. It's really true. It happened in our place.
Madam
Yes, go
Chair,
ahead.
how, city prosecutor, how
Yes.
did that happen if he or she is the leader of the gang? Then he or she would
It
have
did
acted
happen
with
because ano na
discernment, right?
siya, he has been in and out of the rehab. He has really the murder talaga siya, and he was able. He has a charism. He has this leadership. Yet he could influence others, even the adults.
Yes.
Hindi
In
ba
that
meaning
sense,
nun, dapat
he or she would have
nakasuhan pa rin
acted with
siya?
discernment. And
Nakasuhan siya
9344,
actually,
he would
but
be
then he
guilty.
was proceeded upon 9344. That means to say, he was in the rehab. He was placed in the rehab. He pleaded guilty actually, and so he is now under rehabilitation.
So,
Mhm.
but he was
And he was
charged under
even,
9344.
treated well inside. Pinaaral.
Prosecutor
Madam Chair.
po. Yes.
Thank you, Madam Chair. I think this could be resolved if we word this particular provision, paragraph 22, in this manner, that the crime be committed with the aid of a child who is not a co-perpetrator to the crime. But the only issue here is those pertaining to children below 15. Well, it is understood that they are not supposed to be criminally liable. So if we be specific here, then we could state the provision that the crime be committed with the aid of a child who is not a co-perpetrator to the crime. Because I understand the concern of Professor Nohara. If we conduct the inquest proceedings, that could be an issue, because if the arrested person is 17 years old and the crime is committed with the aid of another 17 years old, then there could be a difficulty in applying this particular aggravating circumstance, because the 17-year-old will most likely be charged as a participant to the crime. Then how are we going to apply the aggravating circumstance? Thank you, Madam Chair.
Prosecutor, una po muna si Professor Palarca.
Thank you, Madam Chair. Good morning, everyone.
Morning.
I believe the discussions here focus on about three situations. The first situation is when a child is used by offenders. So that's the first situation. And I think this is what's contemplated in this aggravating circumstance. The second situation is a child is a co-perpetrator together with the offenders. And the third situation is a child, being a co-perpetrator, uses another child in the commission of a crime. So these are the three situations that could be covered by this article. And I think the best way to be able to rationalize this provision is, as what Professor Dan Kalika said, we use the terminologies under RA 9344, that the offender makes use or takes advantage of a child. Because if it's a child who's a perpetrator, anytime a child is involved, the revised penal code will probably take a backseat to the provisions of RA 9344. And if the child commits a crime without discernment, and the child is automatically exonerated. Now, liability arises if the child has committed it with discernment. But 9344 provides a mechanism by which we deal with juvenile delinquents or children in conflict with the law. So even if they acted with discernment, that does not preclude the child from being subjected to the aggravating circumstance of using another child in the commission of a crime. But the child will still be proceeded against using the provisions of RA 9344. So it may be an aggravating circumstance. The crime may be exacerbated by the use of another child by a child who's committing a crime as a co-perpetrator. But in the end, it will be 9344 who will still, which provisions of 9344 will still govern. Thank you, Your Honor.
Thank you very much. Any further comments? Prosecutor.
My apprehension, Madam Chair, is when the child is one of the co-conspirators there. Because we all know that if he is a co-conspirator, there is a collective liability. But when you apply Republic Act 9344, magkakaroon siya ng privilege mitigating circumstance. So, iba na yung penalty with respect to the child offender, the CICL, vis-a-vis the other co-perpetrator or co-conspirators. We should try to avoid that. Magkakaroon ng absurd situation na iba yung liability niya as regards the other co-conspirators. That's why we have to be specific whether he is a perpetrator or a conspirator or just a mere accomplice or just a mere he is there in order to aid other principal perpetrators. That's my concern, Madam Chair.
Prosecutor, okay, can you enlighten us? What's the wrong thing about there being a different liability pag ganun nga?
Let's assume this. A, B, and C conspire. Tapos si D, kinuha nila. At party siya ng conspiracy. A, B, C told D, o ikaw, ang magiging role mo lang, pumasok ka sa bintana kasi maliit ka. At once na nandun ka na sa bahay, sa loob, buksan mo na kami. Well, yun lang role mo. But even if napaka minor yung kanyang participation, since he is part of conspiracy, the law will treat him as ang liability niya, parang liability na rin ng A, B, and C. Because he is part of conspiracy. The act of one is, kad natin to ng below 18, may liability siya. Dahil under the law, more than 15, less than 18, and he acted with discernment, he is a criminal. That's why we should avoid that confusion by stating here a specific age.
No.
That's my concern, Madam Chair.
Madam,
Okay po.
thank you, Madam Chair. I fully agree with Professor Nohara. So then perhaps to simplify things, we can add in this particular provision, Madam Chair, that the crime be committed with the aid of a child below 15 years old, because they have no criminal liability. Then we do not have to make an evaluation whether the child acted with discernment or not, or whether he should be included in the charge, because they have no criminal liability below 15 years of age. Thank you, Madam Chair.
Thank you. Attorney Bilang.
Building upon that, maybe we could expand it to that the crime be committed with the aid of a child who did not or does not incur criminal liability under the provisions of this code. Just saying it's just below 15 years old will exclude those who are above 15 but below 18 but are not acting with discernment. In Prosecutor Nahara's example, for instance, if the minor D was 17 years old, pero inutusan lang siya. Hindi niya alam what the entire plan was, but inutusan lang siya na buksan yung pinto, buksan yung bintana. You could say that the 17-year-old kid was not acting with discernment in that instance. So there's no criminal liability on the part of the 17-year-old. That should also be considered an aggravating circumstance on the part of the adults in question. So again, I reiterate, perhaps we could use that the crime be committed with the aid of a child who did not incur criminal liability under this code.
Attorney Barito. And then Prof. Dan.
Madam Chair, I support Attorney Bilang's position, but my wording is that the crime be committed with the aid of a child who acted without volition or free will.
Taking down Professor Dan.
Madam Chair, we'd just like to reiterate the term minor offenders is not in our legal jurisprudence or laws at present. There's no minor offender, there's no child offender, but the term used in Republic Act 934 for our children in conflict with the law, or CICL. Okay, so there's a shift in the treatment of children in conflict with the law under Republic Act 9344. That's approved already by Congress. So we're just trying to, because the term with the aid of a child was utilized or was enacted in 1932. So that's quite an old provision already. We're just harmonizing it with the law passed by Congress already. And this proposed aggravating circumstance apply only to offenders who utilize children. And under our Family Code of the Philippines, we know who children are. These are under 18 years old. Okay, so this is established also, but in the recent special penal laws, it also includes adults who do not have the capacity over 18, but 18 and above, but don't have the capacity to protect themselves, which has already been approved by Congress. And I suggest we incorporate that also in this criminal code, because that's already the standard definition of a child. Okay. Now we're talking of children, as Professor Palarca mentioned. There are three possible view of how a child may participate in the commission of the crime. And the first one, he or she is in conflict with the law. That's covered already by Republic Act 9344. Now, what if he or she is utilized in the commission of a crime? That's also provided in Section 20C of Republic Act 9344. That will be considered as a special aggravating circumstance on the part of the adult utilizing the child. And that's already approved by Congress. But I agree that there's a specific age in Section 20C over 12 and under 15 years old, because these are the children who are exempt from criminal liability, and that's why the criminal syndicates or the offenders will use them, because they know that the child will agree, because the child does not have any criminal liability. But I think that's quite limited view, because the adult criminal may also use over 15 and under 18 who are still considered as children. So in present law, under 18 cannot contract, cannot enter into legal contracts. In fact, in statutory rape, a person under 16 years old cannot provide consent to a sexual act. I think the persons under 18 are still vulnerable, a vulnerable sector, and they can be utilized by criminals or criminal syndicates. That is why we propose that will be a special aggravating circumstance on offenders or criminal groups or syndicates which use these children, regardless of the age. Okay? Under 18 or over 18, but are
Without
incapable of protecting themselves. So, thank you.
Okay, Prosecutor Abadia.
Whenever, Madam Chair, thank you for acknowledging. Whenever we discussed the provisions during our CCC meeting, I always keep in my mind that this bill is very important, because this could be the bill, the law which will prevail decades from now. Just as the first one was in 1932, and then it took us until 2025 to finally try to revise it. My view is this: instead of limiting the law, why don't we just retain it as it is, in the sense that there will come a time in the future that there might be changes in the concept of child. There might be concept in the changes of what age is exempted and what is not. So that's why it may be not progressive, but we might have an advantage that we just limit it to child so that in the future there will be more leeway, not limiting but more broad. Thank you, Madam
If
Chair.
you, instead of putting an age.
Yes, Madam Chair. Retaining
Yes.
it as child.
Retain it as child. Yes,
Good
Prosecutor
morning,
Herrera. Good
Madam
morning,
Chair.
ma'am.
In support of her statement, I think we have to reiterate that this provision itself is intended really for the offender.
Correct.
So if we
Not for the
expand
child.
it might create more complications. After all, crimes committed by child in conflict of the law is already covered by
9344.
specific law, the Republic Act 9344.
Correct.
My 2 cents worth.
Yes. Thank you very much. Okay. So, where are we? Wait, Kong Ana is still taking down. Oh, you have suggestions, my dear.
Madam Chair,
Yes.
may I be recognized?
Okay.
Hello.
Last po, attorney.
This is just my attempt to reconcile the positions presented. Perhaps we could use the wording that the crime be committed by utilizing an exploited child. An exploited child is the term used in Section 20C of RA 9344, which covers all circumstances. Aside from profiting, there's also inducement by and abuse of authority, etc. So by utilizing an exploited child or those over majority age when such persons are incapable of taking care of themselves, those wording, and when said child or person does not act with discernment in the commission of a crime.
Attorney, so what is the definition of exploited child under
Um,
9344?
because it's quite longer than what was previously mentioned. Makes use, takes advantage of, or profits from abuse of authority over the child, or abuse of confidence, with abuse of confidence takes advantage of the vulnerabilities of a child and induce, threaten, or instigate the commission of a crime. It's really quite broad under the
It's a little
9344.
broad and no, I understand you, but mas mahirapan na to ang
Yeah,
ating
it's quite
prosecutors,
hard.
no?
But under that, it's currently under our laws an aggravating circumstance already. I mean,
Yes.
perhaps because then if kasi hindi naman po natin ma-repeal si 9344 by this would still stand as an aggravating circumstance separate from 22, so paragraph 22.
Okay. Last round of comment regarding her suggestion. Anyone? For me, it's a little. Yes, ma'am.
Just my 2 cents worth lang, ma'am. If we include the term exploited child, maybe we need to prove that in court again. So it will be a burden on the part of us, the prosecutors, to
There are
define.
different
Yes, we have to. If we indicate that in the information that there's an aggravating circumstance about an
all
exploited
of
child,
the
yes, we have to
elements of
provide evidence and supporting evidence to prove that there is indeed an exploited child. So maybe based on the comment of Chief Prosecutor Abadia, maybe we just retain the wording as it is. So thank you, ma'am.
that the crime be committed with the aid of a child, and well, again, under our laws, we have a definition of a child under the family code, and then it has been expanded to include people over the age of 18 but who are not able to protect themselves. Is that correct? So, Prof. Dan, your
Madam Chair.
suggestion was to include takes advantage of the child.
Which is the aggravating circumstance, Madam Chair, because with the term with the aid of a child, that is precisely what is the concern earlier of Prosecutor Nohara. Because if it is with the aid of the child may be complicit to the commission of the crime.
But
So
what do we
that's
want
the
here?
difficult. That's already covered by Republic Act. What we're saying is that's covered by Republic Act
Okay. So because
9344.
aid means the child is helping you, whereas this aggravating circumstance, what we are focused on is that element that makes it worse for the offender. Diba?
Yes, Madam
Okay.
Chair.
I want yes, sir.
The complication would be in a finding where the crime is committed in conspiracy with one another, because if a co-conspirator is a child over 15, say 16 years old, but who acted with discernment, he is still a child. The accused would still be considered a child. But he is a co-conspirator. So in the information, we are going to allege that the crime has been committed in conspiracy with one another. So conspiracy, so the act of one is the act of all. So how are we going to distinguish now the criminal liability of a conspirator who, by the way, who incidentally is a 16-year-old child who acted with discernment? But who is a co-conspirator?
Ganun, hindi ba po mag-a-apply yung 934?
Yes. Madam Chair, my brother is also a prosecutor, so, and I was with the honorable prosecutors. I don't see the concern. Of course, in the information, the child will be included as one of the accused. Okay? But it is already long established that a minor over 15 and under 18 who acts with discernment will be entitled to the privilege mitigating circumstance. So I don't see the problem with the child in conflict with the law being included or impleaded as one of the co-conspirators. So all of them will be equally guilty, but under our existing laws, the child in conflict with the law will
Have
be
a
entitled to a
privilege
privilege mitigating
mitigating
circumstance. So I don't see any problem in the information pa honorable prosecutor.
Yes,
Thank you.
Professor Palarca.
Well, Your Honor, aggravating circumstances are personal to the accused. So regardless of whether you acted in conspiracy, these aggravating circumstances will only apply to a particular situation. Yes, to the specific person, Your Honor.
Thank you. Okay, Kong Ana or Kong Agay.
Madam Chair,
We add this.
so, we move that the provision be amended to instead say to take advantage of a child, but we retain the child in so far so we can keep the spirit if there are changing circumstances and take into account also all the definitions as right now.
Okay. Second. Okay. So we amend paragraph 22 as earlier stated with by including takes advantage of a child and there. Next. Comments on the other aggravating circumstance. Yes, prosecutor.
Allow me to point out again some confusing provision.
Yes.
I'm referring particularly to art number 21,
Okay.
that the crime be
bond.
committed by bond. So the same number provides for a definition of a bond, that a bond consists of 4 or more armed malefactors acting together in the commission of the crime. Now, in paragraph or number 23, we have also this provision that the crime be committed with the aid of armed malefactors who ensure or afford impunity. Now, there is a problem here. The law defines a band as a group consisting of 4, at least 4 armed offenders. Now, in number 23, there's no definition who is or what is armed men. So can we identify if, for example, there are 5 malefactors? Will we consider both band as number 21 and armed men in number 23 as two separate and distinct aggravating circumstances? Because this is the problem of the Supreme Court. How do we treat armed men? So there is no band if the number is not exceeding 4. But if it is less than 4 and assuming 3, they're all armed, well, number 23 will apply. But the problem lies if there are more than number 4. How are they going to be treated? Are they banned or are they armed persons?
Si Prosecutor Nohara,
Thank you.
ang daming tanong sa DOJ, sila gumawa nito.
I'm just throwing the decision, the point to the body, Madam Chair.
You weren't consulted by members of DOJ. No, but we're having a healthy debate here.
Yes.
Okay.
Madam Chair.
Wait, can I just read this so that it's a little lengthy. 21, that the crime be committed by a band or by any person who belongs to an organized or syndicated crime group. A band consists of 4 or more armed malefactors acting together in the commission of a crime. An organized or syndicated crime group consists of 3 or more persons collaborating, confederating, or mutually helping one another for purposes of gain in the commission of any crime. 23, that the crime be committed with the aid of armed malefactors who ensure or afford impunity. Actually, yung 21 pa lang mismo parang problematic na siya, no? Yes. Okay, Attorney Bilang.
Yeah, I share the same concern when I was reading it. On top of what Fiscal Nohara pointed out, there's also a complication with organized and syndicated crime. There is a hairline distinction between a band and a syndicated crime, but if you think about it, what's the difference between acting together and then mutually helping one another? Also, apart from 21 being confusing, in relation to 23, there's also that jurisprudence on abuse of superior strength, which we are retaining. So there are some cases where if it's done by a number of people, that's also considered abuse of superior strength. So I also throw the question to the body, how do we now appreciate that in a case where all of those things are present? Thank you.
Yes, Prof. Dan.
Madam Chair, these are two differently recognized aggravating circumstances. And actually, in the revised penal code, there's a ban, and then there's a criminal syndicate under Article 62. They're different, no, from each other because a 4-person group may commit a crime just for that specific crime. And there's a ban. But a criminal group or syndicate, that's already legal association under Article 147. They form a group, and then it is for the purpose of committing any of the crimes under the RPC. So there's a distinction between a band and a criminal group or syndicate. Okay? And in fact, if the crime is committed by a criminal group or syndicate, that's a special aggravating circumstance. If it's committed by a band, it's just an or generic aggravating circumstance. So what I'm actually suggesting is that we separate the two, paragraph 21 by a ban, and then if committed by a criminal group or syndicate, we should be considered as a special aggravating circumstance. I understand the concern of Prosecutor Noara with regard to the first two paragraphs of paragraph 21 and paragraph 23, that's it's committed by the aid of armed malefactors now in the proposal, not just of armed men, because it might involve women also in the commission of crimes. But it is qualified by the phrase who ensure or afford impunity, because even if it's committed by a ban, there's no impunity in the commission of the crime. But I think it may be they may be consolidated. The commission of a crime by a ban and by armed malefactors who ensure or afford impunity. I think they're somewhat similar po, Madam Chair. But I suggest we separate if it is a crime committed by an organized or syndicated group, that should be considered as a special aggravating circumstance po. Thank you po.
So, tama ba po ang intindi ko? The back
When it comes to band, Spanish Penal Code. That's why when the Madam Chair was asking about whether can we provide a provision, that is a very good suggestion, Madam Chair. Otherwise, we will be going against the established jurisprudence established by the Supreme Court with respect to a bond.
Okay. Attorney Kirby.
Thank you, Madam Chair. So this is regarding the definition of organized or syndicated crime. So the definition here is very close to the definition under the UN Convention Against Transnational Organized Crime, which states an organized or syndicated crime group consists of 3 or more persons existing for a period of time, collaborating, confederating, or mutually helping one another for the purpose of obtaining, directly or indirectly, a financial or other material benefit through the commission of any crime. The difference between the wordings in the bill and the provision in the UNTOC is, number one, in the UNTOC, it must be existing for a period of time. So it cannot be spontaneous because that's not really the nature of the organized or what we call syndicates. And the second is the part in the bill that says for purposes of gain in the commission of any crime. In the UNTOC, it's more specific. It's for the purpose of obtaining, directly or indirectly, a financial or other material benefit through the commission of any crime. Also, we would like to note that in the UNTOC, it's recommended that participation in an organized crime group be a separate or distinct offense. And the rationale behind this is that if there's a syndicate, it's hard to pin down the big fish, the financiers, only through conspiracy provisions or our provisions on principals, accomplices, etc. Because usually the person who sets the objectives of the organized criminal group and the leader usually only acts through intermediaries and doesn't really talk to the actual actors of the crime to commit the crime, etc. Thank you so much. That would be all from my part, Madam
That's
Chair.
very interesting. Okay, Attorney Bilang.
Just on the number, I remember you, Madam Chair, asking where did the number come from.
Yes.
I'm personally of the opinion that we are not married to the present jurisprudence. Yes, there is an interpretation that it's 4. When you think of band, it's a minimum of 4 people. But that was the Supreme Court interpreting the old law, the 1930s law. So feel free, Madam Chair, if you want to change it, make it 3, make it 5.
I'll make
You
it
are well
7.
within your power to change it. Thank you.
So powerful. powerful. Okay. Banda kasi. Kaya ako apat, di ba? Okay. Wait. Professor Borja.
Thank you, Your Honorable Chair. Also for the enlightenment of the chair in the committee, with respect to the number of persons that constitute a syndicate or an organized crime syndicate, meron pong tatamaan na special penal law on swindling, because in that particular special penal law, what it considers to be a syndicate would constitute 5 or more persons. So yes, I agree that we have to come up with an understanding on the number of people involved in the syndicate. As far as qualified trafficking, another special penal law, exploitation of children, what else? Yun naman, 3 or more nakalagay. So yung estafa lang po yung 5 or more. Opo. Thank you.
One of our guiding principles in this subcom is generosity to future law students. Let us be nice to them, because it was very difficult to study all of these terms na 4 dito, 5 dito. Di ba ho? So, ayun. Okay, going back. So, we will retain band, and then we will have a number for band. Do we want to separate the syndicate? That was a first suggestion. Ihiwalay yung syndicate para hindi siya confusing, right? Of course, yung 23 nga po, that is also different because it is the aggravating circumstance of using armed malefactors. Okay. So let's define a band now. Yes, 4 seems to be a magic number. Is there anything that will prevent us from making it 3? Again, or 3 is not too big a group for it to be a band. Is that the general sentiment? Parang band, medyo malaki na yun, kaya 4. Quartet. Parang banda nga.
Your Honor, if we're going also to consider to easily remember what constitutes a band, ang turo ko sa mga estudyante ko, band, so 4 letters, so 4 people. So,
Madam Chair, in my case, a musical band because it has
Ganyan, musical band ang iniisip ko eh. Beatles ba? Ganun. Yes, ma'am.
Madam Chair, so far, I think we are in unison that 4
Yes.
can comprise a band. Is that okay? I think so.
Okay. Okay. A band consists of 4 or more armed malefactors. Does it have to be armed? Yes. Okay. Armed malefactors acting together in the commission of a crime. Okay. So let's separate that from the aggravating circumstance of having a syndicate. Okay, enlighten me again. Shall we have a separate provision here, or dahil may mga syndicated estafa na yung ganon, they're punished under special penal laws, kailangan pa ba ho yung syndicate, the term syndicate here?
Yes. Madam Chair, I think we need crime committed by a criminal group or syndicate. In fact, that's under international law also. syndicated estafa is different, Madam Chair, because
from
it's a crime
committed
and it
by a syndicate.
describes the nature of the crime.
Correct. I remember
Correct.
there are some elements for it to be a syndicate, to be syndicated estafa.
Yes.
So,
I just want to mention, Madam Chair, that in the RPC now, a criminal group or syndicate is 2 or more persons. In the draft, it's 3 or more. Is there a in the UN, in the international?
It's also 3 or more, sir.
3 or more. also.
okay, let's follow the UN.
Is if I may,
Yes.
ako po.
Yes, ma'am.
Ano po, actually precisely to comply with the UN, that's why we changed yung under the present Article 62 of the RPC to 3.
To 3.
And
Okay,
also to make it
perfect.
easier.
Yes. So a band has 4, a syndicate has 3, but they're collaborating, confederating, or mutually helping another for purposes of gain in the commission of any crime. Yes, that definition is okay.
Yes, sorry. The definition is very close. So under the UNTOC, it's an organized or syndicated crime group consists of 3 or more persons existing for a period of time, collaborating, confederating, or mutually helping one another for the purpose of obtaining, directly or indirectly, a financial or other material benefit through the commission of any crime.
How about we adopt the UN definition of a syndicate? So we're automatically compliant with the UN standards, which would be the highest standards in the world, diba? Okay, Attorney Kirby. Okay, so 21, we will insert syndicate under 22 using the UN definition. Going back, 23, that a crime be committed with the aid of armed malefactors who ensure or afford impunity. So here, the difference is, okay, what's the difference? Because, una, there's a band. A band is one that has 4 armed malefactors. This one can be 3, 2. So there are 2 of them who are armed, and then they ensure or afford impunity. Example nga, sir. Sorry po,
Madam Chair.
Tagal na ng law school.
Yeah, Madam Chair, yung aid of armament kasi, yung present wording, ay these men do not constitute a band. But if they do, kakainin na siya ng band, in our example sa 21. But if they do not constitute, dito sa 23 siya. So, ang ibig sabihin ng armed men or armed malefactors, less than 4. At least, kasi pag more than 4 na siya, or 4 or more, and they're armed, kakainin na siya, band will now absorb aid of armed malefactors. Ganun po yan, Madam Chair.
Sir, is the difference the number or the line here which says who ensure or afford impunity?
I think sa present wording, sa present revised penal code, there's no such word. Let us check. Aid of armament.
Madam Chair.
Yes, go
Yeah.
ahead po, sir. Go
Yep.
ahead po.
My students often ask me this as the same question. What's the difference between band and bend? And the simplest explanation I could offer them is, when you talk about band, they are complicit in the commission of the crime. They are actively participating. But when you talk about aid of armed men, they could just be standing by, waiting to rescue you in case something happens. An example I give them is, let's say you got into a fight and you had armed men with you. If the armed men join you in the fight, then that's a commission of a crime by a band. But if they just stand by, waiting for you to need assistance, then that's aid of armed men. Ang sabi ko sa kanila, pangpalakas ng loob and rest back for you to be able to commit a crime because you know that you have help behind you.
So,
Madam Chair.
so it's literally aiding them, but they're not part of the whole plan.
Yes, Madam Chair, may I be recognized?
Yes, sir.
Yes, I agree with Professor Palarca that in aid of armed men, ang participation lang nila is mere accomplices. But if they are co-conspirators or principals, hindi na sila aid of armed men. It will no longer constitute aggravating because they are not complicit. So para magkaroon ng aid of armed men, ang role ng armed men is a mere accomplices. So accomplice lang sila. That is the jurisprudence, Madam Chair.
Okay, thank you very much. Now it's clear. Parang ang daming provisions, tapos parang, when do you apply these, diba? Yes, Attorney Bilang.
So may we be more explicit in 23 that if it's already committed by a band, 23 no longer applies? Just so there's guidance for everybody. We're talking about law students being criminal law that's going to bind everyone. So might as well guide everyone and be clear that they are mutually exclusive of each other. Thank you.
Well, first, dapat iangat natin para lang they're all talking about groups.
Ni Harvey Bilang, the judge considers it separately. So you don't need to specify it that it doesn't. You don't need to apply if you're going to apply this one.
Yun nga po, actually, I'm coming from the perspective also, like, I'm representing Ateneo now, but also for my full-time job, I'm working at the Supreme Court. And I see RTC judges also doing that, like appreciating aggravating circumstances separately when it should be just one of them, like mutually exclusive of one another. So I said that also for the guidance primarily of RTC judges.
Okay. Yes. So I think we're okay. We're okay. So 21, 23 we have, and then we will have a new provision for syndicate. Can you?
So, Madam Chair, we propose that
You move to adopt
we move to adopt that we
or amend.
to amend. Okay, so the definition of 21 in this that the crime be committed by a band, and we retain the definition of a band as one which consists of 4 or more armed malefactors acting together in the commission of the crime. And we create a separate provision on organized crime and adopt the definition as defined by the UN. And we propose also, pagsama-samahin natin, Madam, hindi po malito yung mga estudyante. Muli, dapat sumunod na yung the next should be that the crime be committed with the aid of armed malefactors to ensure or afford impunity, Madam Chair. And then
Okay, so there being a motion which is duly seconded, we adopt 21 as amended, and a subsequent paragraph on syndicated crime as worded by our UN friends, and we bring up the provision on the aid of armed malefactors as the next provision. Okay.
Madam Chair.
Next. Yes,
Can I move to add the provision in aid of armed men?
Yes, okay, what's that?
So that the crime be committed with the aid of armed malefactors to ensure or afford impunity, provided that this aggravating circumstance shall no longer apply if it's already committed by a band.
But diba it's given na naman?
Yun nga po, ma'am, kasi minsan it's appreciated twice. There are some people who mistake that they're separate aggravating circumstances.
Madam Chair, may I be recognized?
What's the
Yes, I agree with Attorney Villang. But napakahaba yung kanyang
Provided it does not fall
provided
under-
that it does not constitute a bond. That is simpler, I think.
Yes.
Thank you, Madam Chair.
Thank you. Okay. Okay, next. Next, comments. Yes, Attorney Hernandez.
For
Hold on everyone, please go ahead and eat. It's a working lunch, courtesy of Attorney Agay Cruz today. Alam mo, nagpapatawa lang tayo Thursday. Tayo lang nagtatrabaho. Okay. Go ahead, Attorney Hernandez of PAO.
For paragraph 24, for the positive finding for the use of dangerous drugs, we suggest that can we insert a phrase after confirmatory test, just so it's clear. I understand that this provision came from RA 9165, Section 25. The law, insofar as the aggravating circumstance is concerned, does not specify the requirement for a confirmatory test. However, the provision about being guilty for the use of dangerous drugs, the provision in RA 9165 requires that it is after a confirmatory test. So just so we're clear, for this aggravating circumstance, to avoid it being misconstrued when it is applied
Okay.
in
Can we
information.
look at the original? Is this a new one or?
It's a new provision.
Absolutely new provision, di ba? Wala namang ganun noon on drugs.
I think it's taken out from a special law, RA 9165 po.
Yeah. Wala naman tayong ganun noon. Okay. Kayo po muna.
Maganda yung may confirmatory test because, again, it makes it easier. Kanya lang sa akin, would it mean that, if a crime is committed, automatic ipapatest na natin? Baka maging burden yan sa mga police, maging burden yan sa mga law enforcement, that if a crime is committed, automatic ipapatest nila yung accused kung meron bang ginamit na drogas or whatever.
For the appreciation of this aggravating circumstance, that a confirmatory test be also specified for this provision.
Attorney Borja, Professor Borja po muna.
Thank you, Your Honor. We will be taking a step back on the proposal that a positive finding would serve as an aggravating circumstance. But firstly, we would want everyone to know that we recognize the evils and the dangers of dangerous drugs and its use and how it affects people's lives. But including this as an aggravating circumstance for all types of crimes may have some dangerous effects and violations. Firstly, it was explicitly provided under RA 9165 that a finding of a positive use could only serve as an aggravating for any crime that is only a violation of the law itself. So that's one. Second, it was clarified in the case of De La Cruz, which echoed the sentiments of the court in social justice, that requiring or making the finding of a positive use of a dangerous drugs would, other than a violation of RA 9165, would somehow be have harmful effects. Okay, it also require each and every commission of the crime it was also require our law enforcement authorities to conduct mandatory drug testing on every suspect of a crime. That's the second one. And third one would be, I came across a case of, it's not really all about use of a drugs, but it's more on the aggravating circumstance of cruelty. It's a case of People versus Sitchon. Of course, when we appreciate cruelty, there should be a showing that the accused had inflicted unnecessary harm out of sadistical bent. But in that case, it was proven that the accused was under the state of drug use or under the influence. So the court held there that it's not really out of the crime that was not committed out of sadistical bent, but simply because the accused was under the influence of drugs, and his use of drugs actually diminished his capacity to perform the crime. So this shows that it doesn't really mean that if a person is under the state of drug use, it may somehow mean that there's already a perverse attitude to it. And in fact, on a case-to-case basis, it may diminish his or her capacity to act. And then lastly, perhaps there would be situations wherein the accused may have committed a crime, okay, but incidentally he or she was in a state of drug use, meaning the very purpose that we're including drug use as an aggravating circumstance would be counterintuitive. Halimbawa, nagnakaw lang yung isang tao, tapos nagkataon, high siya nun, meaning hindi niya talaga ginamit yung paggamit ng droga para lang ma-facilitate yung crime, then somehow that would not be aggravating in itself. Okay. Thank you, Your Honor.
I would like to support the statements of Professor Borja. I also would like to request the deletion of this aggravating circumstance, or at the very least, it be put in the alternative circumstances. Because, if, for example, intoxication, we treat that as an alternative circumstance because when it's not habitual, when it's not done subsequent to the plan to commit a crime, it actually diminishes your capacity. And again, the bedrock of criminal law is you punish an evil mind. And when you're under the influence of a substance like alcohol, or in this case, positive dangerous drug, it may be said that it's not really you that's acting. It's not your evil mind, but rather it's your lesser inhibitions because of the substance. So perhaps I echo what Professor Borja said, that it's counterintuitive to put this as an aggravating circumstance for all crimes, and perhaps we can just include it as an alternative if we really want to.
But one comment lang po. Aren't we removing alternative circumstances? In which case, do we put this? Do we put it under mitigating and aggravating then? And if so, kindly provide us with your suggested wording. Who raised their, Prosecutor Nohara?
Madam Chair, with respect to this proposed aggravating circumstance, well, with due respect to my colleague, Professor kami ng San Sebastian, si Attorney Bilang, and si Attorney Borja, magkasama kami yan sa UP, panel of experts. Madam Chair, the matter of use of dangerous drug has been recognized as an aggravating circumstance under Republic Act 9165. In fact, Section 25 of the law expressly provides that if there is a finding of positive use of dangerous drugs, it shall be a qualifying aggravating circumstance. It is now a law. What we in the DOJ Criminal Code Committee what we did was merely to lift Section 25 at inincorporate namin sa proposed Article 13. And secondly, Madam Chair, under Republic Act 10586, the so-called Anti-Drunk and Drug Driving Act of 2013, driving under the influence of dangerous drugs and other similar substances is now a crime. So if you are found driving under the influence of dangerous drug, that will be a crime. Here, if you commit a crime under the influence of dangerous drug, that is a mere aggravating circumstance. Just like the use of loose firearm. If you use a loose firearm in the commission of the crime, nang hold up ka, it will not constitute a separate crime but a mere qualifying aggravating circumstance, the effect of which is to increase the penalty. So, ganyan din po ang in-envision namin dito sa paragraph 24. The only problem here is that there is no categorical provision with respect to the confirmatory test as suggested by Attorney Maria Hernandez of Pau. There should be, because in the case cited by Attorney Borja, in the case of Piper versus De La Cruz, there must be a confirmatory test. But it was, again, expanded. Sabi ng Supreme Court, there should be an initial screening test and there was the subsequent confirmatory test. So I would agree with Attorney Hernandez for the inclusion of that phrase to make this more clear, Madam Chair. Thank you very much.
Attorney Kirby, do you have comments here? No. Okay. Next. Attorney Barrido.
Madam Chair, nabanggit na po ito kanina, no? Sa PNP manual kasi, wala pong SOP doon regarding sa drug testing sa mga nahuhuli. So, to my mind, hindi ba magiging subjective sa law enforcement kung sino lang yung kanilang itetest for drug use? Or, if mailagay ito, mare-require ang state na gawing SOP yung drug testing for all crimes involving yung mga minor crimes like gambling, yung mga ganon. So, yun lang yung concern ko. Yung sa PNP manual.
I understand that it will be tedious. Unang-una, actually, hindi ko po maisip kung how this will apply. Meaning, kailangan, you know, when a crime is reported, makikita nung huli, police, that there are drugs there, or that the person who committed the crime had just used drugs. Ganun ba po? And then, sige nga po, Prof. Dan.
Madam Chair, in Republic Act 9165, its Section 36 provides for the instances wherein mandatory drug tests can be conducted. And Section 36F, if I recall correctly, or G rather, was declared unconstitutional by the Supreme Court. That Section 36G is subjecting one who is charged with the prosecutor's office of a crime involved, which is punishable by more than 6 years. The Supreme Court declared that unconstitutional already. And my concern is with placing this as as an aggravating circumstance may bring about unconstitutional drug testing po, because aside from those mentioned in Section 36 of RA 9165, as mentioned by Prosecutor Noara, there are only two other instances in Republic Act 10586, the Anti-Drunk and Drug Driving Act, wherein drug testing would be allowed. And as mentioned by my colleague, Professor Borja, the Supreme Court may declare that only those arrested or apprehended for violation of RA 9165 can there be drug tests. Not just confirmatory tests. I think that's required, that there should just both be screening and confirmatory tests. No? All instances. And secondly, Madam Chair, one who is found in use of a dangerous drug will be guilty of illegal use of dangerous drug under Section 15 of RA 9165. So it might not be appropriate to make it as a aggravating circumstance when it's a crime in itself in Section 15 of RA 9165. but limited only to those arrested or apprehended for violation of RA 9165 and probably for violation of the Anti-Drunk and Drug Driving Act. Okay, so it's a separate crime in itself, and Republic Act 9165 tells us what's the declared policy of the national government with regard to drug abuse and use. It is not to punish these persons, but to rehabilitate and reintegrate these persons to society. So I think it would be similar to the alternative circumstance of intoxication, but as suggested earlier, we should remove alternative circumstances. So if we pursue this, there should be a clear, or actually our suggestion is to remove it entirely, Madam Chair. Okay, but if ever this is incorporated, there should be protection on the fact that no drug test should be allowed pursuant to existing laws. It should be under our existing laws. And second, it should be somewhat similar to intoxication, Your Honor. In fact, I have a suggestion as recommended by the Madam Chair with regard to intoxication. There's a clear standard already under Article 15. If it is habitual or intentional, then it will be aggravating. I suggest that it be incorporated in the aggravating circumstance.
Magiging ano to, yung mga ating kapulisan ay aabusuhin tong provision na to. But there must be an aggravating circumstance on this. Kasi may mga crimes, heinous crimes na kukumit na kung addict o nasa high yung tao, di ba? Mga benting saksak yan. Nakukumit lang yan pag wala sa katinuan yung offender. So pag nasa tamang katinuan siya, hindi siya gagawa ng ganon kung hindi siya under the influence of drug. Ang tingnan lang natin to, how can we prevent abuses on the part of the law enforcement agencies na baka mamaya gawin tong isang rason na naman para sila ay makapangharas ng mga ordinary citizens. That is all, Madam Chair.
Thank you very much. Okay, were you raising your hand, Attorney Barrido? Sige po.
Madam Chair, isn't that pag gumagamit po ng droga, yung judgment ng accused ay naapektuhan? So with more reason na yung intent niya o yung overt act niya, wala siyang control doon, no? So, and then gagawin nating aggravating. So that's my point, Madam Chair.
But,
Lalo na yung mga yung talagang addicted. So may problem sa kanilang volition.
But I agree with the DOJ. It goes both ways, Madam Chair, because one may take drugs so that he or she will be emboldened to commit the crime, just like in intoxication.
Yes.
Okay, so that's why I said it could go both ways. But our concern is that it may create a floodgate to abuse, as mentioned by Prosecutor Noara.
Yes.
And it's very clear already in Republic Act 9165. I did not see RA 9165 being incorporated in the criminal code. Would that be correct? No, hindi siya naka-incorporate dito. So it's still that's already covered. What I'm saying, and I hope the DOJ will agree, it's already covered by existing laws. And then there'll be a separate prosecution for
the use
violation of
drugs
Section 15. Why would we make that another aggravating circumstance po?
Madam Chair.
Yes.
So thank you, Professor Dan, for supporting my stand on this. Can we just make more clear the provision on Article number 24 that can we just specify the crimes na nakomit ng offender para siya subject to drug test? May I propose if heinous crimes, those heinous crimes, pwede natin i-subject siya sa drug test. Pero kung traffic violation naman, hindi naman pwede. Pero pag mga heinous crime, just like rape, murder, or other kidnapping or arson. Pwede natin siguro subject to drug test yung offender doon. So, para hindi naman lahat ng crimes na napaka unjust vexation lang, idadrug test mo. Yun. That's my suggestion, Professor Dan. Thank you, Madam Chair.
But that's precisely what was declared unconstitutional by the Supreme Court in Social Justice Society, crimes punishable by more than 6 years. So I would like to adhere to such ruling of the Supreme Court, and then just apply what is existing already in RA 9165 and RA 10586 po. And I'm just concerned because he or she will be made liable for violation of Section 15, and the law is quite clear. If it's the first offense, he or she will just be rehabilitated for 6 months. And then if it is the second offense, there will now be
more
a
severe
imprisonment after the
penalty,
second
yes.
offense po.
Attorney Bilang, last na po.
Supporting Professor Caliga also because yung sa drug testing, when you're an accused person, inosente ka pa eh. And there are many instances where the person being charged is not the author of the crime. There was an author of the crime, but it's not the person being charged. So if you subject that person to drug testing already, magpa-positive sila for use, you're basically incriminating the person for nothing. No? So just want to make my objection on the record with regard to that proposal, and also to just to allay the fear. So if you are someone who did a crime, a heinous crime because of a drug, it's not the absence of an aggravating circumstance does not make it, does not let you go scot-free. You're still going to be liable for the heinous crime. Sinaksak mo ng 20 times, liable ka pa rin for cruelty and ignominy as the case may be. So, hindi natin kailangan yung paragraph 24. Thank you.
Okay, thank you very much. Okay, can I hear a motion?
Madam Chair, we propose to delete the provision on that there is a positive
24.
finding, Section 24 as worded in the House Bill.
Okay, that is seconded. We will delete Section 24 of the House. Paragraph 24. Okay. There's a new provision, paragraph 25, the crime committed for racist reasons or other crime of discrimination and related to ideology, religion, ethnic origin, or ethnicity, cultural affiliation, gender, sexual orientation against the offended party. Is that a good wording for this? Go ahead. Sorry po. Yes, prosecutors.
Actually, we added this number 25 because we were debating of whether or not we will delete Article 133 of the revised penal code, which is offending religious feelings. So I was proposing that instead of offending religious feeling, to replace it with something that has positive harm on account of the discrimination, on account of religion, etc. Positive, because we also recognize that there are hate crimes. On point, the Marawi Shids, churches were burned because of religion, because they hated Christians. So that really happened in our country. So we're thinking that in offending religious feeling, it is a protecting sensibilities of a person. Take into account the case of Demetriou Harriet, where she filed a case against a priest when the priest was in the pulpit, and he said something about the lady mediatrix of apparition of the lady mediatrix, I think, and then Harriet Demetriou was a devotee of this lady of mediatrix apparition, and so the priest said something that was offensive to the feelings of Demetriou. So she filed a case against the priest, and then it was actually dismissed by the court. But then the priest posted a bail, so she went really into that process. So we were thinking that instead of offending religious feelings, then it should be something that has actual harm, no? And so, but my group suggested that instead of presenting another provision, instead we will have to make this aggravating circumstance instead of replacing this Article 133 to another provision. And so this is now the suggestion of the group. The crime committed for racist reasons or motivated by discrimination based on ideology, religion, ethnic origin or ethnicity, cultural affiliation, gender, then add sex, sexual orientation of the offended party.
Yes, ma'am. Actually, if I may say first, I'm okay with this provision. I think we will just have to reword it.
Yes.
No? Ayusin lang natin. Yes, Prosecutor Janet.
Madam Chair, it's just a suggestion if
Yes.
we can make it more profound, considering that this is a crime that is not focused on discriminatory intent, and it also includes prejudice, biases, and hostility, not only with respect to race, sexual orientation. Can we also include disability, social status, or any personal or collective identifiable characteristic of the offended party?
Okay, that's very good po. I will just ask for your suggested wordings on this one. In the meantime, yes, sir.
If I recall, Madam Chair, there was a move last time that this will be incorporated with number 3.
Number 3.
The crime be committed in the disregard of
With
the respect
insult,
due to the offended party on account of rank, status, age,
or gender.
or gender. Then we add number 25, or that the crime is committed with discrimination relating to race, ethnicity, religion, ideology, gender preference, and social station.
Disability. Madam Chair,
Yes.
I think 25 is very specific. It should be motivated by discrimination. But whereas the number 3 is disregard of sex, etc., gender.
Sige po. We'll get the suggested wordings for this one. Okay, and we will. Okay. Can you just move to approve this? Oh, we're done with the Yes. Oh, we'll subject style.
Madam Chair?
Yes, okay. Last po. Go ahead. Ay, sino? Prof. Borja.
Thank you, Your Honor. In order to modernize the section aggravating circumstance, we also propose the inclusion on cybercrimes. Under the cybercrime law, that if a crime has been committed through a computer-generated system or other means that may be devised in the future, that will serve as an aggravating circumstance. During the pandemic, nauso po yung online shopping. So maraming na-scam. So there's an example of cyber estafa. We have this case of People versus Catan, wherein there was extortion that was committed, but it was done through Facebook Messenger. So that's cyber extortion. And then yung pagpo-post sa social media na pang-aanoy, so that's also cyber unjust vexation. So thank you, Your Honor.
Okay.
Madam Chair.
Okay. Attorney Sampaga.
Madam Chair, can we adopt the definition of racial discrimination under UN International Convention on Elimination of All Forms of Racial Discrimination po?
Okay.
It says that it shall mean any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin, which has the purpose of, or effect of nullifying or impairing the recognition, and etc. po.
Okay. Sige po. Please give us the wordings and we will integrate. Attorney Kudan.
Madam Chair.
Kudadas.
Regarding the suggestion of Professor Borja, Your Honor, Madam Chair, actually it is included in Article 353 of House Bill 7142 and 7206. So it states there that commission of a crime by, through, and with the use of information and communications technology, blah, 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 shall be a cybercrime, provided that the penalty to be imposed shall be 1 degree higher. So it is included in 353 and not in the aggravating circumstance. So it's in Book 2 of the proposed bill.
Bakit siya naka-separate?
It's a separate. Because, Your Honor, if it's an aggravating, it's just 1 level higher. So, magiging maximum lang.
Yeah.
But if it is a cybercrime, pag 1 degree, at least 1 degree talaga siya. Oo. So, parang pinababaan natin if we put it as one of the aggravating circumstances.
Yes, yes, I stand corrected. Thank you. Thank
Okay,
you.
perfect. So let's remove that. In that case, we will just reword 25. Can I get the suggested wording from you, ma'am, and from the UN wording, and then we'll see how we will patch things up. Okay, so you can move. Yes, please. You can move.
Okay. Madam Chair, so we move to adopt and approve the paragraph 25, subject to amendments and style.
Okay. Seconded, we adopt number 25 and we will restyle it. Yay, we're done with aggravating circumstances. Or not.
Just one more
Yes, Professor
suggestion,
Dan.
Madam Chair. Because there's no rule providing which are generic aggravating and special aggravating circumstances. So I suggest at the end of the 25th aggravating circumstance that we state, Madam Chair, that this is provided actually in the rules of court already, Rule 110. The aggravating and qualifying circumstances shall be alleged in the complaint or information and proved during the trial to be appreciated by the court. That's one additional paragraph we recommend your Madam Chair. And then the other one is we specifically identify which are special aggravating circumstances among the 25 or so enumerated aggravating circumstances, which include, Madam Chair, the aggravating circumstances in paragraph 1, which is taking advantage of one's public position, quasi-recidivism, and if it is committed by a criminal group or syndicate, and taking advantage of a child, we suggest that this be specified as special aggravating circumstances, which will result to the penalty being imposed in its maximum period, and which cannot be offset by an ordinary mitigating circumstance. Well, thank you, Madam Chair.
Thank you. Okay. We will include those special.
Although, Madam Chair, I just want to state for the record that the Supreme Court might think this is an encroachment on the rulemaking power with regard to Rule 110, but we're suggesting this because it's legally mandated. It's a right of the accused that that it's in the Constitution po that the accused should be properly apprised of the nature and cause of the accusation against him or her. And I think this is part of the legal mandate of Congress that Congress may specify which that the aggravating qualifying circumstances should be alleged in the information in order to be appreciated against the accused who's later convicted of such crime. And the rules of court, as we know, can be altered or amended by the Supreme Court. And then there are no vested rights in the rules of court. So if we place it in the criminal code, that will be a legally mandated right of the accused.
And then they will just change the
Yes.
the rules
Thank you,
of
Madam
court,
Chair.
like they always do.
Just a point of observation. I don't know if it is a case of oversight. I'm looking at House Bill number 7142.
Yes, sir.
The
Sir, what
the-
paragraph?
there's no mention about cruelty here. The present wording, the present Article 14, the last enumeration, the number 21 is cruelty. I don't see any provision in the draft regarding cruelty. That's the most important, one of the most important aggravating circumstances.
Isn't it sa paragraph 16?
Can I see? Saan siya? Yes, there, 16. Na-move ba po siya? Okay. So, Professor Dan, we will get the wording there. Let us not talk about encroachment here. For the record, I just saw in my Viber group that the Supreme Court just issued a clarification on the threshold, on the date for the impeachment. They said it's January 15, after we did all of that. See, I say everything with a smiling face. Hi. Okay. Yay, so we're done with aggravating circumstances. We are removing Chapter 5, alternative circumstances. So we proceed to Title 2. Yay. Wait. It's 12:30. We can maybe we can end at around 2 o'clock if that's okay with everyone. Matagal-tagal niyo po ako hindi makikita. I'm going to the UN. For Women's Month. It's another thing that has been keeping me busy. Yun naman. No, I'm a vice chairperson of Women and Gender Equality. That's why I strongly objected and moved to strike from the records the statement of my friend. Now we are not talking so much anymore. Okay, Title 2, persons criminally liable for crimes. Article 15, who are criminally liable? Okay, what's the difference? Criminal liability shall be incurred by natural persons. The following are criminally liable for grave and less grave crimes. Okay, kasi dun sa una, felonies siya. The following are criminally liable for light crimes, principals, accomplices. So it's similar to the old Article 16. Criminal liability of juridical persons shall attach in instances and manner indicated under this code and by special laws. Are you okay with that?
Yes.
Yes, Attorney Kirby.
So UNODC supports criminal liability of juridical persons. This is in compliance with the UN Convention Against Corruption, the UN Convention Against Transnational Organized Crime, and the UN Convention against, but also it's a bit dated. But the minimum requirements under the code, under the conventions are that each state party shall adopt such measures as may be necessary, consistent with its legal principles to establish the liability of legal persons for participation in the offenses established in accordance with this convention. So the minimum would be money laundering, corruption, participation in organized crime, and cyber crimes. So I think the Philippines has to decide whether this applies only to grave and or less grave offenses and also to very specific crimes.
Okay.
Another requirement is that the liability shall be without prejudice to the criminal liability of the natural persons who have committed the actual offense, and that the legal persons held liable in accordance are subject to effective, proportionate, and dissuasive criminal or non-criminal sanctions. So that's about it. I would also like to share that this weekend, I will be joining the Securities and Exchange Commission in joining an event in Sri Lanka on corporate criminal liability. And we will be producing the outcomes of this event to see how other ASEAN countries have drafted their laws on corporate criminal liability. And we will be happy to submit this report to the Honorable Commission.
Sure. Yeah, in fact, we've been talking with Attorney Kirby, and we attended the UNODC forum on AMLA. On AMLA. Kaya this is an important provision, insertion. Comments? Yes, po.
Thank you, Honorable Chairperson. Just a matter of style, maybe we could expressly and categorically state under Article 15 of the proposed bill to include juridical persons. So criminal liability shall be incurred by natural and juridical persons. Thank you.
Yes. Mag-move pa ba to? Sabi ko lang, adapt na. Okay, so we're adopting Article 15 as worded, and of course we will edit it a bit more for style purposes. Article 16.
Madam Chair.
Yes po.
There's, of course, this is quite a significant change in the criminal code that we're recognizing that juridical persons are also criminally liable.
Babalik ba tayo sa ano?
No, that's also already recognized in Article 2, then now here in Article 15
yes,
po.
It's here.
So,
Okay. There.
it states, however, that it will be subject to the provisions of the code and special penal laws. So I would like to suggest the adoption of one of the phrases in the UN Convention that the criminal liability of juridical persons will be different from the criminal liability of the natural persons who perpetrated the criminal act. And then we also suggest, based on the, I think this is in the Cybercrime Prevention Act, the wording, juridical persons shall be held criminally liable for crimes committed in its name, on its behalf, or for its benefit by its legal representative, or by a natural person acting either individually or as part of the organ of the juridical person who has a leading position within the juridical person. At least it gives a guide on when a juridical person will be held criminally liable. And the phraseology, the next part, the liability imposed on the juridical person shall be without prejudice to the criminal liability of the natural person who has committed the offense.
Okay.
Of course, the state is immune from suit, so we have a definition of juridical persons, Madam Chair, in the Civil Code. I'm just, of course, we also, I don't know if we include the phrase that except the state.
Yes, agree. We agree, Professor. We agree, first of all, also to maintain the wordings, as you have mentioned. We have to separate the criminal liability of natural persons and also juridical persons, because at this point, we haven't decided yet for which crimes, for which we will require specific crimes only, like a schedule of offenses, or only for less grave or grave offenses. So this will give us a lot of flexibility later. The other thing is, Sorry, Professor, what's the other point? Yes, the definition of juridical person. Yes, we will follow the one stated in the Civil Code and also the revised Corporation Code, and this excludes GOCCs. Thank you.
Okay, so we will get the definition from the Civil Code, and then we will also put that the criminal liability of juridical persons shall be separate from that of the natural persons who were involved in the crime or who perpetrated the crime. Okay. Prof. Dan will get the wordings para sakto po. Article 16, I don't think there's anything that we should debate on here. It was just reworded. It was retained.
For 16, I have.
Okay, Attorney Mila.
May I suggest the adoption of number 4 in the second column of the matrix for HB numbers 5446?
Okay, our original bill.
Yes, because I note that we only have a definition of what conspiracy is under Article 8, but it doesn't really specify that it's a mode of incurring criminal liability. So it might be better to be explicit in Article 16 that even conspiracy is a mode of incurring criminal liability as well. Thank you.
Yes. Oo nga naman. That's our original bill. Yes, ma'am. Prosecutor. Ma'am, please press your microphone.
For Article 16, Paragraph 3, I suggest that the wording will be like cooperates in the commission of the crime by adding performing. So by performing another act without which the crime would not have been accomplished, instead of commission of the crime by another act.
Cooperate in the principals are those who cooperate in the commission of the crime
By performing another act without which the crime would not have been accomplished.
by performing another act without which the crime would not have been accomplished.
Just a suggestion.
Okay. Yes. Yes, ma'am. It's a matter of style. Okay. So as suggested, we will amend. We will include the number 4 for original House bill, and then we will reword number 3 also. So we adopt number 16. Number 17. Accomplices are those persons who, not having acted as principals, cooperate in the execution of the crime by previous or simultaneous acts. Is there something questionable there? Or tama naman ang who? I think it's just a better wording for accomplices kasi in the existing code, accomplices are those persons who not being included in Article 17. So, okay, we adopt number 17. Accessories. Oh, ito mahaba-haba. Okay. Take part to its commission in any of the following manners. By profiting themselves or assisting the offender to profit by the effects of the crime, or by buying, receiving, possessing, keeping, acquiring, concealing, selling, or disposing of, or buying and selling, or in any other manner dealing in any article, item, object, or anything of value which he or she knows or should be known to him or her to have been derived from the proceeds of the crime. Kinuha to sa ano? Sa antan fencing, no? By concealing, destroy. Okay, that's the same. Number 3, by harboring, concealing, or assisting in the escape of the offender. Or 4, ito pala may 4. By any other act or omission that will obstruct, impede, frustrate, restrict, or delay the apprehension of the offender and the investigation and prosecution of criminal cases, unless the act is separately punished under other provisions of this code or by other special laws. If the act is penalized by any other law with a higher penalty, the higher penalty shall be imposed. Comments. So number 1 is fencing. Number 4, anong tawag dyan? Obstruction of justice. Wait. Obstruction of justice is it's a separate, is it in a special law? It's not in the revised penal code. Okay. And why are we putting it here if it's in a special law na? Or it considers other...
Madam Chair, may
Yes,
I
go
recognize? Are we referring to number 3 or number 1? Number 4.
Okay, let's go to number 1. Are we okay with number 1? Yes. Yes.
Under the present provisions of the revised penal code, there is a need to qualify the crime committed by the principal. The accessory will exist if the principal commits any crime other than robbery or theft. Because if the principal commits robbery or theft and the person is in possession of that item subject of the thievery or robbery, he will be considered as fence. So under the proposed draft, we will not qualify what crime was committed earlier by the principal. As long as he is in possession, he is considered an accessory. I think that is the provision of the proposed draft of this.
Prosecutor, should we insert a short statement except as provided under the anti-fencing law or something like that?
Yes, Madam Chair. But the wording here is the crime. That is a generic word.
Yes.
It does not qualify what crime is committed earlier by the principal, whether it is robbery or theft or any other crime.
So by profiting themselves or assisting, so except if the crime is robbery or thievery, in which case the anti-fencing law will apply.
Madam
Yes?
Chair, of course, I hope I understand that the purpose of the codification is to eliminate other special penal laws, and Presidential Decree 1612 was passed during the previous administration of Ferdinand Marcos, and PD 1829 also. So we're trying to incorporate it in this article, since these persons really are accessories, they're just penalized with a higher penalty, and the third mode of being an accessory is quite restrictive under the current revised penal code. So, in fact, I agree with the incorporation. There's just an intended effect in the first accessory that the penalty will be 2 degrees lower, which is not in harmony with the purpose of PD 1612, which is to increase the penalty for fencing. But we were discussing, of course, a fence is much lesser, should have less liability than the thief or the robber himself or herself. No? So this might be okay. And then the third subparagraph pertaining to obstruction of justice, this is also good because the definition of the third mode of accessory is quite limited only to certain crimes. So this will cover all possible obstruction or frustration of the wheels of justice. But again, the unintended effect is the penalty will be, I think, much lower also, 2 degrees lower also. I'm just clarifying if that's the objective of the draft. Thank you.
Thank you. Okay.
I respond to that, Madam
ahead.
Chair. Yes, Professor Dan, that is our objective, is really to prevent a situation where there is one case but there are 2 laws involved. So here in number 3 or number 1, in number 1 you have to consider also the anti-fencing law. So medyo malabo yun. So we are just harmonizing these 2 laws. Na pag if you are in possession of an item which was earlier stolen, then you can be charged with as an accessory. Now, in number 3, there is no more delineation with respect to what kind of accessory is involved, because in the present law there are 2 kinds: the public officer who abuses his function and he harbors, conceals, or assists the principal to escape, and the other one is public officer who does not abuse his function and private individual. In the second situation, there are only certain crimes covered. If the offender, the principal, committed treason, parricide, murder, or there's an attempt to take the life of the president, that situation was remedied by the anti-obstruction law, that any crime committed by the principal and you help the principal to escape, you are now considered as principal in the violation of anti-obstruction law. That's our intent, Madam Chair.
If I may, to answer for the observation of Attorney Kanika, in this case, the penalty for obstruction of justice would be commensurate to the crime that's being the investigation of which is being obstructed. So it's not uniform anymore for all the crimes. So the heavier the crime, the heavier the penalty for the obstruction. The lighter the crime, similar reasoning. So that's the reason for punishing as an accessory.
Okay.
Any more comments?
Another one, Madam Chair, is with respect to second kind of accessory. So the present jurisprudence says that Article 19 would only be applied if the act involved is committed while the crime has not yet been discovered by authorities. But if the crime has already been discovered and there is an act of concealing or destroying the body, that would be covered by the obstruction of justice law. So here, parang hindi natin na-consider that area where a crime has already been discovered and the person conceals or destroys the body, etc. So I think if this will be adopted, I think the obstruction of justice law is still a good law.
Okay.
That's all.
Yes. Other comments? So, we're okay.
Yes.
Attorney Kirby.
Yes, so for the UN Convention Against Corruption, Article 25 specifically requires criminalization of 2 types of obstruction. One is use of physical force, threats, intimidation, or the promise, offering, or giving of an undue advantage to induce false testimony or interfere with evidence. And the other type is in Article 25B, physical force, threats, intimidation to interfere with official duties of justice or law enforcement officials. So in this paragraph, it's what we're covering is the broad obstruct, impede, frustrate language. but we would like to suggest to explicitly cover the bribery of witness element, the promise, offering, or giving of an undue advantage to induce false testimony. So our suggested addition would be including the use of physical force, threats, intimidation, or the promise, offering, or giving of any undue advantage to induce false testimony or to interfere with the giving of testimony or production of evidence.
Shall that be a separate number? We can talk about the wording, but
Principle of a crime.
okay, Professor Dan.
Yes, Madam Chair. I did not notice that there's subparagraphs 3 and then 4.
Yes.
And then in the escape of the offender, in the previous RPC, it says principal of a crime and then guilty of
treason, parricide,
several
murder.
specific crimes. So when we say offender, of course, that's quite unclear provision. Offender, or of course, that person will still be held guilty first of the crime before one can be considered as an accessory.
Okay, the original one is by harboring, concealing, or assisting in the escape of the principals of the crime, provided the accessory acts with abuse of his public functions, or whenever the author of the crime is guilty of treason, parricide, murder, and okay. This one, by harboring, concealing, or assisting in the escape of the offender.
So, if the person assisted in the escape of the accomplice, it will be included here. Because it's just a principal who's being assisted in the current wording, Madam Chair. And it says, just to protect this person, offender guilty of crime. But of course, in the natural state of events, the accessory will be charged together with the principal, right? And then the principal will be held guilty of, or there's a crime committed, and then he or she is adjudged as an accessory. So I'd just like to add, Madam Chair, in the escape of the principal of a crime, instead of just offender, Madam Chair.
Would the DOJ care to comment?
I
Yes, ma'am.
think we agree with Professor Kalika that instead of offender, we use the principal. Yes. In relation to the revised penal code, original provision also.
Any other comments on to support? So ComSec, we will adopt the use of the word principal instead of offender in order to keep to the spirit of our RPC. And also, we will be adopting the language suggestion based on the UN definition. Okay. Do we have any other comments on the Article 18? Correct? Okay, so we can move forward to Article 19. Has any comments from our resource persons? Accessories were exempt from criminal liability, which states that unless otherwise provided by law, so this was added, the penalties prescribed for accessories shall not be imposed upon persons falling under paragraphs 2 and 3 of Article 17.
with respect to their spouses, ascendants, descendants, adopted children, brothers and sisters, or relatives by affinity within the same degrees.
Madam Chair, we support the House Bill 7142 approach. The unless otherwise provided by law qualifier ensures flexibility for special laws such as anti-trafficking, anti-money laundering, where the family exemption could be exploited.
Madam Chair, I think there is, I think we have to correct this. Instead of Article 17, I think this refers to Article 16, if I'm not mistaken.
We will fix it. We will renumber it. Okay, but yes, Attorney Bilang.
Just a matter of style po, with regard to the phrase with respect to their spouses, ascendants, descendants, etc. Can we clarify it and instead use when the principal is their spouse, ascendant, descendant?
Prescribed for accessory shall not be imposed upon those persons falling under. Oh, you mean just make the wording better?
Yeah, because with
So we won't
respect to
have
there
to-
is a bit vague.
Yes. Okay. Just to make it clearer, sige nga, Attorney Bilang, give us the wording.
So, shall not be imposed upon those persons falling under paragraphs 2 and 3 of Article 17 when the principal is their spouse, ascendant, descendant, adopted children, and so on.
Principle. Okay. Okay, so we will adopt Article 19.
Madam Chair,
Yes.
just a matter of style with regard to adopted children, Madam Chair, because that's included already in the descendant. If a
Yes,
child,
it's always our
I think we will have a rule on construction or interpretation later. And then it excludes paragraph 4. The previous exemption is just for those who also benefited from the effects of the crime. Why is baka it's just inadvertence that paragraph 4 is not included in the exemption, Madam Chair, because I think in paragraph 3, the principal is guilty really of a crime, but in paragraph 4, it includes only a suspect who later on may be judged to be not guilty of any crime at all. So I think we stick with the current exemption in Article 20 of the RPC that it excludes only those who profited also from the effects of the crime, because that person, regardless of his or her relationship to the principal, acted perversely because he or she profited also from the effects of the crime, but helping another person, although it may constitute obstruction of justice, just like in paragraph 3, it's just natural for the mother to help his or her child po, no? So I think I suggest we stick with the first accessory as the one exempted from the absolutory cause in Article 19 po. If that's okay with the DOJ
Okay.
po.
Madam Chair,
Yes.
yes, we see no reason not to consider the suggestion of Professor Carica. Thank you, Professor Carica.
Prof. Dan, can we just get your wording okay?
Unless I don't know.
No. Yeah. Anyway, when we ask naman for your wordings, no pressure. After na.
Simply paragraphs 2, 3, and 4.
Yes.
For Article 7 of the previous article.
Yes. Okay. Yay. Title 3, penalties. Let's go through the preliminary paragraphs. Article 20, penalties that may be imposed. Ang daming dinagdag. No crime shall be punishable by any penalty not prescribed by law prior to its commission. Okay, that's a given. Likewise, when strict application of the provisions of this code would result in the imposition of an unjust penalty, taking into consideration the gravity of the crime and the injury caused thereby, the court shall, without suspending the execution of the sentence, submit to the President through the DOJ its recommendation for executive clemency of the sentence and refer to the Congress for amendment of the penalty. Bakit siya sinama kaya doon? Parang masyadong ano. Okay, Attorney Bilang.
I have a suggestion po that's a bit radical. I suggest the deletion of this is formerly Article 5 of the Revised Penal Code and added to now Article 20. I suggest the deletion of the entire thing because it caused, former Article 5 of the RPC caused the non-development of our jurisprudence in cruel and unusual punishment.
Sorry, Article 5.
Formerly Article 5 of the Revised Penal Code. So we have in our Constitution Article 3, Section 19, which provides for the prohibition against the imposition of cruel and unusual punishment. And where we got that from, the U.S. Constitution, they have a rich jurisprudence on the punishment fitting the crime. Now, here in the Philippines, we don't have that. Because whenever accused persons challenge the severity of the penalty, Article 5 was used as a justification. Well, Article 5 says when the penalty is unjust, the power of the Supreme Court is to refer it to Congress and to refer it to the DOJ for clemency. But that's not really how it should work because, as we know, the Supreme Court has the power to enforce the Constitution. So I guess for the harms it causes, I respectfully move for the deletion of Article 20, for that part of the former Article 5. Yes, the ones that are in all caps.
Yes. Can I hear from the DOJ, someone, since this is... yes.
I respond to that, Madam Chair.
Yes, sir.
So, if we will agree on the proposal of Professor Bilang here, mawawala na yung Article 5 of the Revised Penal Code? Is that what he meant for?
Yeah, because in any event naman po, the Supreme Court always has the power to refer cases to the Executive Department and the Legislative Department, and it's still their discretion whether to adopt the Supreme Court's recommendation. Nothing will change. It's just that the harmful explicit wording of Article 5 from before gives the impression that the Supreme Court doesn't have the power to meddle with criminal penalties. It does.
Well, Madam Chair, I think Article 5 is still useful. Now, we have here Article 20 because this serves as the guidance for the lower courts, for judges of lower courts. So we have here the principle of nolium crimen, that if there is no law that penalizes an act, the court should acquit or dismiss the case. On the other hand, we have also that principle of jura lex sed lex, that if there is a law, that law must be respected regardless of the sympathy or feelings of the trial court. So the trial court has option in both instances to submit or the recommendation to the chief executive through the Department of Justice for the possible enactment of that law, or possible revision or amendment of that law which it finds to be cruel or unusual. So I think this is still important, Madam Chair.
Sir, can you give an example for this one? When will it be an unjust penalty?
Unjust penalty. Maybe there is it is a situation where the court will impose a penalty even if there is no law that penalizes an act. That will be unjust.
No,
So,
I mean, kasi there should always be a law to penalize an act. So there will be no situation wherein the court will impose a penalty.
I would assume, Madam Chair, that if, for example, the trial court judge erroneously imposes a penalty for a non-existing crime, so that will be unjust penalty. So this is just a guide that if that case happens, the court should invite the attention of the president or the chief executive for a possible enactment of that law or possible amendment of the law. So this is just a mechanism attached to the law, that in case this really happens in the future, this is the thing that the trial court or the Supreme Court should do, to invite to recommend the possible enactment or amendment of the law.
Madam Chair? Yes. If I may give an example, one clear example of this was in the case of Corpus in 2015. So that was the case that brought to the Congress's attention the unjust results brought by the fact that 1930s pa yung RPC, but yung crimes natin on theft, robbery that are based on values, monetary values, have not been adjusted. And in that case, Article 5 was used. The court recognized that yes, it was unjust. Yes, we recognize na yung 30,000 noong 1930s, so it merits this very, very long punishment, but now it doesn't. But the court felt like it was in a difficult position because it's what the law says. Like Professor Nahara says, jura lex sed lex. And we can use Article 5 because our duty under Article 5 is to refer this to Congress, to refer this to the DOJ. But what I'm saying po is, without this provision, it probably would have signaled to the court that no, you have the Constitution. You have Article 19, Section 19 sa paragraph 1, which is enforceable. It's under Article 3. Now, we have a situation where Article 3, Section 19 sa paragraph 1 means nothing in jurisprudence. There's no case saying that a very, very long imprisonment is cruel and unusual punishment.
Okay.
If I may. Thank you, Madam Chair. I think we take the position also more aligned with what Professor Bilag from Ateneo had been taking. No? If we do not delete this entire amendment, the one in caps, no, I think one way to improve this then would be to say specifically, to clarify what unjust penalty means by inserting cruel, inhumane, unjust, and cruel, inhumane, and degrading into the description of the penalty. And then the other thing that could be done to improve this amendment is also to remove the prescription on what judges can do. Keep it open-ended and allow them to take measures that are allowed under law. One other thing that we can add to this is I think under an unjust penalty, taking into consideration the conditions of a prison. So I think generally we know that national policy right now is on decongesting prisons. There's an acknowledgement that prisons are generally not fit for the safekeeping of human beings. Another way of looking at a penalty in the concept of unjust is not just on the duration of the penalty, like it's over what the law prescribes. It's more on, it's not commensurate to what the law meant to impose on the person. That is to say, for a duration, but not under degrading conditions, for example. So I think that might be a way to clarify this and to accommodate both the need of the DOJ to sort of retain this as well, and still take the point of Professor Bilag on we need to develop jurisprudence on cruel and degrading and inhumane treatment.
Got it. Okay. Professor Dan.
Madam Chair.
Yes, po.
Yes. This is not a new provision. This is already in the Revised
Yes.
Penal Code, Madam Chair,
Yes.
Article 5 of the RPC. And I don't find anything objectionable to this provision. In fact, the Supreme Court itself recognized that there could be an unjust penalty in the case of corpus versus people, as mentioned by Professor Bila. And that's possible, but the rule is that dura lex sed lex, the law is harsh, but it's the law, so the judge should impose it. But this is quite a good provision because it empowers or it mandates the judge, although the Supreme Court might get angry again, mandates the judge to report to the chief executive for exercise of executive clemency or to the DOJ to coordinate with the legislative branch for possible amendment of the law. And these legal provisions are helpful because and in criminal law, that provision in the civil code that if there's a lacuna or obscurity in the law, that's not usually applicable to criminal law, Madam Chair. Okay, and if this is just a surplusage, I think it's a good surplusage.
Okay. How about the suggestion of Attorney Nick to clarify what unjust penalty is? I mean, we can retain it, and then, yes.
Yes, I do agree with Attorney Dr. Tobia that there is some confusion or vagueness in the draft. But can I suggest that we can just adopt Article 5 to be incorporated in Article 20, the present wording of Article 5 of the revised penal code, because to avoid any confusion, there have been cases decided by the Supreme Court invoking or citing Article 5. So there's nothing wrong with Article 5, Madam Chair.
The term used in Article 5 is clearly excessive penalty.
If I may
Yes.
yeah, I totally agree with what they said. From on its face, there's nothing really wrong with Article 5. What I'm saying is in application, it tells the Supreme Court it has nothing to do. I'm going to give a hypothetical. If there was a law that imposes life imprisonment for jaywalking or a traffic violation, we can all agree that's too excessive. But when that comes to court, Article 5 tells the judge, no, impose life imprisonment on traffic violation. What you can only do is refer it to the DOJ, refer it to the Congress to change the law. That's not really what judicial duty is all about. You have the cruel and unusual punishment clause in the Constitution to declare that unconstitutional. So, yes, there's nothing wrong inherently with how Article 5 is worded. But what I'm saying is its presence, its mere presence in the code has ripple effects in application. Thank you.
Thank you.
Madam Chair,
Okay.
with due respect to Attorney Kabilang, I think if the Supreme Court will be given that discretion, that wide discretion, magkakaroon na judicial legislation yan. The Supreme Court cannot question the wisdom of the law. The Congress has the power, has the plenary power to enact laws. Walang pakialamang Supreme Court dyan if it is contrary to the Bill of Rights. Pwede yun. But until such law is declared unconstitutional, we have to respect that by virtue of the so-called separation of powers. Di ba?
May I respond, Madam Chair?
Go ahead.
Huh? Go ahead.
Yeah.
It's not judicial legislation because you're enforcing the Constitution. The Supreme Court does meddle with legislation from time to time. Our jurisprudence on due process is rich with declaring unconstitutional laws. No? And why does criminal law have to be different? All criminal laws end with deprivation of life, liberty, or property. Why do we carve out criminal law from the application of the Constitution?
Okay. Attorney Nick.
If I may, no, although judicial review is a sensitive topic right now, no, I think maybe an alternative example to prosecutor Nuhara could be let's not nail ourselves to the idea of duration of penalties only as an issue that the judiciary has to address. No, it could be something different. No, let's change the terms of an unjust penalty. No, so if a jail is congested, we can draw examples from other jurisdictions in other countries where if a person needs to be sentenced or committed to a corrections facility, what a judge could do is take a second look at the detention of someone who's already in there and sort it by who's nearest their release dates, and then release them on the equivalent of what would be self-recognizance for us, until the point where, okay, now there's a slot available inside this facility. And that way, without suspending the sentence, we can already commit this person to serve their imprisonment penalty. So again, no, it's not just addressing unjustness because of the duration. It's the totality of the conditions of their penalty.
So in which case, we do refer it to the Supreme Court.
Or the judge could take measures. And that's why I'd recommend that if we were trying to find the middle ground, maybe we just remove the prescriptions on what a judge could do and allow them to take measures that are allowed by law.
May I
Yes,
speak
ma'am.
din po? In support lang of our position and also of what Professor Calica said, I believe what this provision contemplates is not the inherent unfairness of a law that may be stricken down for being excessive in its penalties, but the application in certain circumstances when it would be unfair, which is why the mention of malice and injury is made here. So it's for the fringe cases when the law as worded, which is not contemplated as being excessive in itself. Parang may presumption na this law does not violate the Constitution. But when you apply it, it may be unjust. So it's just contemplating those very specific instances and not yung when the Congress may be very heavily using its hand in passing laws. So I don't think the situation that Attorney Bilang is mentioning is the situation being contemplated here. With due respect.
That's our favorite line, with due respect to the Supreme Court. Sorry. Okay. So what now? Madam, ikaw, ano gusto mo? You know, because I see, of course I see Nick's point. He's my friend. He's my batchmate. Okay, I understand. And like Attorney Dan said kanina, if it's a surplusage, then just let it be a good surplusage. I'm inclined to retain it with due respect. But can we get the wording lang of UN? And let's see if we can incorporate it. Okay, so we'll adopt in the meantime Article 20 as worded. Article 21, construction of criminal laws. Criminal laws are prospective in application. They shall have a retroactive effect when favorable to the offender unless otherwise provided by law. Noon, penal laws shall have a retroactive effect insofar as they favor the persons guilty of a felony, who is not a habitual criminal, as this term is defined in Rule 5 of Article 62 of the Code, although at the time of the public... Okay, syempre mas maganda yung wording now. Gosh, yung mga pinag-aaralan sa law school na pinakahirap-hirap lang talaga nila yung wording, di ba? Pwede namang perspective. Okay, everyone's in agreement with this wording? Yes. Yes, let's adopt 21.
Madam Chair,
Yes.
sorry. Agree with the proposal. Just wanted to add a second paragraph, if I may.
Okay.
I raised this before in the second or third hearing. Just want to repeat it right now. So, since we're in construction of criminal laws, if we can add the second paragraph saying that unless otherwise explicitly provided by the provision, all criminal laws are to be construed to require a mental element to constitute the crime. To explain lang po ulit, this comes from the perspective that we as law students and now lawyers we're taught the concept of mens rea in law school, but that's not something that's widely out there for the public. So we want this document that's going to be used by the public to recognize that criminal law punishes the mental element, the mens rea component. And this is the proposed wording for that. I think what I'm also trying to achieve by adding this is to give the impression that criminal law has to mean something, meaning you're punishing the evil. It's not just a checklist of acts na pag nagkamali ka, makukulong ka, but rather, you have to act with some evil purpose in mind before you get incarcerated. So, kung pwede po, yung second paragraph is that, no? That all crimes have a mental element, except if the provision explicitly provides that it's mala prohibita or that's a strict liability crime. Thank you.
Thank you. Yes, ma'am.
With all due respect, that would be very, very difficult for the prosecutors to prove in court. It is already very difficult for the prosecutors to prove motive as of the moment. And then if we add in that mental element, that would be the end of the prosecutors.
Ma'am, pero di po lahat naman po mala-inse. So talagang pinoprove din naman talaga. We're just making it explicit right now.
Yes, but if we're going to include in the information explicitly the mental element that the good lawyer is asking for, then we'll have to have one more element or one more fact that we need to prove in court.
Yes. Yes, a third. One of you.
Thank you, Your Honor. Also respectfully to my colleague, we were colleagues before in the Supreme Court. I remember that the intention of recodifying the RPC is to make things simpler. We integrate the SPLs. So it would appear that yes, there's mens rea, but it may only affect for mala-inse crimes. So if the intention is also to integrate special penal laws or other statutes, not only special penal laws that are mala prohibita by their nature, it might create confusion. Not only will it also require an added burden to the prosecution to prove mens rea, it will also create confusion with respect to the different crimes that require mens rea or naturally just because the statute would prohibit itself. But that's just my 2 cents. Thank you po.
Professor Dan?
Yes, I think we are beyond that already. With due respect, I would like to take on the add in Article 3 because crimes can be committed with intent or fault. I think that's included already there. There's
Yes, in
intent,
Article
intelligence, and freedom of action. I'm going to another point, Madam Chair, if that's okay, but we can continue with that discourse.
Go ahead.
In the RPCV4, it says unless otherwise, unless the offender is habitual criminal or delinquent. No? My concern with this provision, unless otherwise provided by law, it opens up a can of worms, Madam Chair, no? So, if favorable to the person guilty of a crime, should always be given retroactive application. I think this became an issue in the GCTA law because what is provided in Article 22 in the RPC is just a habitual delinquent with specific crimes attached to a habitual delinquent, robbery, theft, falsification. It does not cover those who are guilty of, for example, a recidivist who's guilty of 2 crimes of rape or murder. That's graver than a habitual delinquent as defined now in the RPC. But then that really became possible because there's no death penalty that can be imposed in the RPC now. Okay, but habitual delinquent is now defined in the draft, and it says here that habitual delinquent is one who is guilty of grave or less grave felonies, as crimes rather, 3 times. Would that be a correct in the draft DOJ criminal code? So I think we can stick with the exception habitual delinquent, Madam Chair, so that there should be no, my suggestion is there should be no leeway or flexibility as to when retroactive application will be not implemented, Madam Chair.
So they shall have a retroactive effect when favorable to. They shall have a retroactive effect when favorable to the offender who is not a habitual delinquent.
This excludes, Madam Chair, recidivists, reiteration, quasi-recidivists, and wherein what will be imposed on them will be an aggravating circumstance or a special aggravating circumstance, Madam Chair.
Yes, go ahead.
I join with the observation of my friend, Professor Dan, but must be specific. Because when we speak of habitual delinquent, we are specifically referring to that aggravating circumstance of habitual delinquency. It would be more proper if we use just habitual offender, so to cover also the concept on recidivism and the other habitual circumstances. So it would be favorable to the culprit and who is not a habitual offender. I would suggest that phrase, Madam Chair. Thank you.
Yes, we took up the different kinds of habitual, yes, under aggravating. Yes, Attorney Bilang.
Just putting on record, your respects are all accepted. but before we leave that, of course, I defer to the wisdom of the body, but just want to put it on record. Yeah. Yung intent in Article 3 is couched more as voluntariness and volition. That's why I'm personally for a mental element. And if I may share, just again to put it on record, this comes from my experience handling cases where IP community, nagputol ng puno without DNR permit. Illegal logging daw kasi walang mental element ang illegal logging. You have to, when you're in the court and you're seeking for justice, you have to find a way to, no, this is not a bad person. This is someone who cut a tree because they want to build a communal toilet for their community. But our status quo right now, where we don't clarify the mental elements, allows the incarceration of people who are not really hindi sila masamang tao, is what I'm saying. But because criminal law is being treated as a checklist of acts, everybody's now going to prison. I mean, not everybody, but we're also handling a case right now but on simulation of birth. Wala namang masamang intention yung lolo, gusto niya lang maayos yung record ng apo niya. Pero dahil, according to the, ito yung checklist of acts that we need to follow, therefore makukulong ka. So, the body can for sure reject my suggestion, but just to put it on record, having a mental element in the offense serves as a purpose. It shields the innocent from undue incarceration. Yun lamang po.
Thank you. I understand. My side comment now is we're always looking for elements. Like yesterday in the justice hearing, some kongs were looking for elements of the impeachable offenses. Okay, Prosecutor Abadia.
We see the point of Attorney Bilang, Madam Chair. However, the accused is not without recourse. That is his defense. And with due regard to the judges, they will consider it to be equitable. So they will consider it in rendering the decision, and there are also mitigating circumstances that can help the said accused. I'm just saying that it is a matter of defense for the accused to say that it was not his intention in the first place.
Okay,
Thank you.
so we'll adopt Article 21 with and then we will insert who is not a habitual offender there. Article 22 is the same. Article 23, measures of prevention of safety. It's the same. Dapat ba nating ituloy yun? O mahaba?
Madam Chair. Sorry, hindi to malaking ulit. For 22, just a matter of cross-referencing. I note that in the proposed bill, Article 66, subparagraph 6, there's also express pardon by the offended party in cases of light crimes. So I suggest that that cross-reference be made also in 22. So Article 22 would read as follows: a pardon by the offended party does not extinguish a criminal action except as provided in Article 344 and Article 66 of paragraph 6 of this code.
Okay. Sige, we will check it later on also in case the numbers move. Okay, let's start with classification of penalties, and maski yung the initial paragraphs before section 1. Yes, ma'am.
With due respect, Madam Chair, can we, for Article 23, I'd like to note lang we're using the word imbecility when we decided previously that we'll do away with the word imbecility. So,
Oh, yeah.
Yes po.
Yes, sige, we will
Remove na lang po, or maybe po. Thank you, Madam Chair.
check our
It's
draft.
the same with Article 11 po.
Yes. See, Article 11. Okay. Classification of penalties, Article 24. Principal penalties which may be imposed. The different classes of principal penalties which may be imposed for violations of this code are the penalties of deprivation or restriction of liberty, community service, disqualification, public reprimand, and fines. And then afflictive penalties, okay. Correctional penalties, restrictive penalties, light penalties, arresto menor or community service, public reprimand. Sa correctional pala naglagay din ng community service. Penalties common to the three preceding classes: fine, or community service. Can someone from DOJ or, well, from UP Law explain the changes under penalties? First, thank you po. Nakain mo akin. Thank you. Okay. So, principal penalties. Okay. Can anyone give an overview of how DOJ or UP Law thought about changing the penalties? Kaya nyo yan, ma'ams and sirs.
Madam Chair,
Yes,
we would like to apologize because the one in charge for this particular provision was Group 1 and none of us belong to Group 1 as of this afternoon.
That's entertaining.
Hindi po Monday Group. We apologize for that.
Oh, it's okay. It's
Madam
okay.
Chair.
Okay, let's get your comments on the. Well, there's not a lot of change here. I think it just clarified the principal penalties.
Oo nga, Madam Chair.
Yes po. Tapos naglagay ng community
RP
service.
Janet.
Sige po. Go ahead, Professor.
RP Janet raised her hand also, Madam
ma'am.
Chair. Can I?
Sige po, ma'am.
Madam Chair, the idea here, Madam Chair, with respect to the classification of penalties, the intention really was not really to deviate totally from the original RPC as much as possible. That was the wisdom given to us. Hence, more or less, the change, the significant change that was introduced here was merely the introduction of the community service. And this is also to address the some problems like congestion of the jail.
Okay. Yes, sir.
In the introductory part of Article 24, we just replaced the word imprisonment with deprivation or restriction of liberty, community service, etc. In the afflictive penalties, in the enumeration of the nomenclatures of penalties, we remove the penalty of destierro. Since I think only 247, Article 247, prescribes the penalty of destierro. So parang kakaiba lang siya. So we remove that and we replace it with community service because that is now institutionalized by virtue of the community service law that the same should be incorporated in the revised penal code. That's all, Madam Chair.
Okay. Yes, Professor Dan.
Madam Chair, I actually, of course, the UP law had a different penalty scheme. And actually, only the nomenclature for the penalties, because they're the same. There's imprisonment, there's restriction of
Yes, there's
liberty, community service, and disqualification, public reprimand, and fines. So it's just the
punitive,
nomenclature.
corrective, restorative.
It is different. And in the proposal of UP, it actually highlights what is the nature of the penalty, whether it's punitive, whether it's restorative, whether it's correctional, in line with the philosophy behind the criminal code that it is both classical and then positivist in nature. Okay, so there's the punitive sanctions for the grave crimes committed by a person. Now, I took a look at the Spanish Penal Code, and unfortunately, they are not using anymore reclusion perpetua. This nomenclature we're using in the RPC. So May I suggest a
We
proposal
like to
to
stick to our Spanish roots.
that we don't use the nomenclature in the old penal code of the Spanish penal code, because it will happen that Philippines is still using the terms used by the Spanish penal code, but the Spain itself is not using this penalty nomenclature anymore.
Oh my
So
God.
I suggest there's in the matrix the suggested penalties of the UP Law Center.
The bill that I first filed.
Yes. But this will require a very huge discussion or extended
Yes.
discussion, Madam Chair.
Emotionally attached tayo. Yes.
I support po yung pag-move on, kumbaga, from the Spanish terms. Although I just want to flag, the Constitution uses reclusion perpetua, the term reclusion perpetua. I think it was mentioned twice.
My God.
So if we move away from the Spanish terms, we may have a problem with that.
We have to amend the Constitution too.
And,
May I add to that? And there are other laws which also refer to reclusion perpetua, just like the indeterminate sentence law and the probation law. So I think we should maintain the nomenclature of penalties as presently worded.
Kung nandito ba si Kong Ana, she will say she attended the Spanish embassy's party one time, and the request was to retain the Spanish words so that we will remember our Spanish past. Okay, going back. Prof. Borja.
Thank you, Your Honor. Just a point of clarification under the classification of restrictive penalties. First, there are light penalties, next arresto menor or community service, and then public reprimand. May I ask what are these light penalties? Thank you.
Wala yung group 1. Okay. Ganito na lang. Since
Your
start
Honor.
na naman to. Yes, sir.
I'd just like to add what Professor Kalika said. When, I was with him when we went to Spain to study the criminal code. Hindi na sila gumagamit ng mga reclusion temporal. What they do is they provide a straight penalty for a crime. Let's say homicide. They provide a straight penalty. They say 6 to 10 years. Ganun na lang. Wala nang kung yung term. 6 to 10 years. Tapos nagtanong kami ng how do you appreciate the mitigating and the aggravating circumstance? They provided a formula which I believe if we adopt it, easier for us to understand lawyers, easier for also the law students to understand, even for theater. The only challenge to that is you will have to provide the duration of penalties for all the crimes that we have. That would take time. Pero madali masyadong maintindihan kahit na yung pag-apply ng mitigating sa aggravating
Intindihan ko po.
circumstance.
Okay. Ganito na lang
Thank
po.
you.
Thank you. Ganito na lang po. Since it's almost 2 and I said we will end at 2, we will have our assignments. What's ComSec? When is our next hearing? Yes, ma'am.
I would just like to address this to everyone in the group that it is the marching orders of Yusek Vasquez to not introduce a lot of changes in the code, in the proposal, because as we can see, we have been seeing each other for how many weeks now, and we're still in article number, we're still in the 20s, because it is already anticipated that it's going to be a lengthy process. And if we're going to introduce a lot of changes in the code, then it will entail more, it will be more time consuming. That is the reason why we we tried to, the Criminal Code Committee tried to introduce changes, but not as much that it will burden the Revision Committee, Madam Chair.
Okay. Well, one thing lang, no? So there's afflictive, there's correctional, there's restrictive, o nagkamali ba to? So light penalties yan, no? Okay. Yes. Okay. So,
our next will be March 16, 24, and 26.
okay, so the next hearings of the subcommittee will be on March 16, 24, and 26, unless COMSEC texts otherwise. 16, 24, and 26, and it might be chaired by Kong Ana Veloso Tuason, because I'll be in UN on the 16th. Pala. 24 and 26, dito na ako. Can we have group number 1 then? Yes, so they can better explain this portion on penalties. And then, for those with wording assignments, kindly give the same to COMSEC na lang po. And we will integrate everything and put it in our draft there. Anything else? I actually had one question. Actually, question ni COMSEC. Nasaan na yun? Anong tanong mo? Ang tanong ni COMSEC kanina, is public reprimand same as public censure? Same. We just reworded it. Because, I was... I was told that I was censuring someone. So I said no. I was just reminding them of proper decorum. Madami akong hugot the past few days. Okay. Well, that's all. Thank you very much. There's a lot of improvement. We moved forward, and we will proceed from penalties in our next hearing with Chair Anna. So thank you very much. This subcommittee meeting is hereby suspended.